May I plead, Lordship? May I plead, Lordship? I beg to mention item number 18, Lordship.
Item number
18, Lordship, with
Ye-
consent of the other side.
18. You're praying for adjournment. Why?
The analogous matter, Lordship, has not been listed today, Lordship. So that is a IAC number 1013, Lordship. So both the matters may be taken together, Lordship, just after
Heard Mr. Ndeka
and Kolita, Lordship.
and Kolita, learned counsel for the
Respondent number 2, Lordship.
respondent number 1,
Yes, Lordship, I am. for
respondent
that.
number 1, who prays for an adjournment on the ground that this matter and another matter which is analogous to this instant matter,
IAC 101.
that is interlocutory application civil number
1013.
1013/2024 has not been listed along with the instant case, and both the matters are required to be taken up together. Hence, he prays for listing the aforesaid matter along with the instant case on a different date. He submits that he has obtained the consent of learned counsel for the applicant, who has no objection to the prayer. Hence, the prayer is allowed. Let this matter be listed in the month of January on a date to be fixed by registry. Date, give a day, 19 January.
Thank you, Your Lordship. So, sir, item number 29, I have the consent of the other side. I'm required to file an affidavit. So, it may fix.
Heard Mr. R. Goswami, learned counsel for the respondent, who submits that he may be granted some time to file a written objection against the application filed by the appellant in this case. He also submits that he has informed the learned counsel for the applicant/appellant regarding his prayer for adjournment, who does not have any objection to the said prayer. Stop. Hence, the prayer is allowed. Let this matter be listed
8th of January.
on 8th of January.
Yes. I will pray for my.
8th of January.
May I please, my lord? My lord, I beg to mention item number 1, ma'am. My lord, I am appearing for the respondent number 8, my lord. I have taken the consent from other side, my lord. My lord, may I pray that this matter may come up after vacation, my lord?
Heard Mr. A.K. Gupta, appearing for respondent number
8, my lord.
8, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed the learned counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to his prayer. Hence, the prayer is allowed.
Can it be on 28th of January to 28th?
Let this matter be listed again on 28th January.
Obliged.
Please, Dr. L, regarding item number 2, my lord, it's wrongly listed for admission. The matter has been admitted, my lord, on 5/5/2017.
It will go for
Hearing, my lord.
hearing. Heard Mr.
Shiladitya
Shiladitya, learned counsel for the petitioner,
petition.
who submits that this matter has been wrongly listed in the admission column. It as the instant civil revision petition has already been admitted earlier. Stop. Registry to list this matter for hearing after Bihu vacation
After
on a date to be fixed by.
Obliged.
Please, Your Lordship. I beg to mention item number 4, Lordship. Consent taken of the petitioner side, Lordship. I am appearing for respondent 2, 3, and 4, Lordship. Madam, you taken up after Bihu vacation.
What is your name?
Be Deuri, Lordship.
Heard Mr. P. Deuri, learned counsel for respondent number 2, 3, and 4, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed learned counsel for the petitioner regarding his prayer for adjournment, who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after Bihu vacation.
I am for the petitioner, Lordship. Interim will be continued.
Reflect, show the name of Mr. M. Das. The interim order shall continue till next day.
Made please, your lordship. Lordship, item number 39. It has been listed at 2 p.m. today. So the IA hasn't been reflected in the cause list. Would it be please called up
What is your prayer?
for the IA, lordship? The IA to be listed. It's fixed at 2 p.m. Item number 39.
Why is not listed? Call for the. Okay.
God bless you.
May I please, Lord? My Lord, today I have filed an IA, urgent matter, Lordship, it may be taken.
Listing,
today.
senior court is there.
Pardon?
Prayer for listing has to be made before another.
No,
court.
that matter is pending before your Lordship.
It is tied up matter,
I have filed today IA.
but it has to go.
An order was passed by this honorable.
But it is not tagged with this. It is not part heard. Any court having taking up roster can take up this matter. You have to mention before the senior court. Though order was passed by this court.
My Lord, I have prayed in my IA for modification, so that will be taken only by your Lordship.
Modification of
Of the order dated 12th of December 25, passed by your Lord.
which case?
In the contempt proceeding. Pride realty.
You have informed the other side.
Yes, sir, I'll serve the copy.
When?
Today. Today, your. I have filed today, only.
Now, when you want listing,
Today at any time.
let it be tomorrow.
Okay,
Tomorrow.
God bless.
I'll take up the matter if it is tied up or if modification is required.
Yes, my prayer is for only for modification.
Okay, tomorrow.
God bless.
May I please, your Lordship, with the consent of the other side, I beg to mention item number 3 for adjournment. Matter may come after vacation. I am for the respondent on behalf of RC Sega Senior Daughter.
What is your name?
JP Burua.
Heard Mr. JP.
Burua.
JP Burua, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed learned counsel for the respondent, learned counsel for the petitioner regarding his prayer for adjournment, who has no objection to his prayer. Hence, the prayer is allowed. Let this matter be listed after Bihu vacations.
Oblige, your Lordship.
May it please your lordship. My lord, I beg to mention item number 33, my lord. It's a part heard matter. My lord, can it be upgraded, my lord? It can be taken up at 2 p.m.
We already have so many matters.
My lord.
Item number
33.
we will take up this matter as after the item number 32. We'll take up this matter today.
My lord.
We'll ensure.
Much okay.
Your Lordship,
Yes.
May it please, Lordship.
Yes, Mr. Das, anything?
Lordship, here the case is earlier rejected and it was clearly stated in the order, Lordship. 7, that Lordship, the court is of the opinion that Lordship, the victim should be examined. then they should therefore reluctant to grant this bail. The bail may approach the trial court for
Victim
regular
has been
bail,
examined.
not examined. Lordship. I want to state that, Lordship.
Upcoming to that much.
Yes,
He should have given me chance.
yes,
After the petition council.
yes, yes. Make your,
22, the Lordship may kindly peruse page. Page 20, Lordship, annexure 3.
page,
Page 20, annexure 3. Got Lordship?
yes,
So 22/7/2025. Lordship, I'm placing this first line. Accused Mustafa Hussain has appeared before this court on receipt of summons with a bail petition. So he has duly appeared on that particular day, that is on 22/7/2025. So on his appearance, Lordship, a bail petition was filed, rejecting which he has been taken into custody. And the prior history is Lordship, a absconder charge sheet has been filed against him. That was the case, Lordship. So his bail application was rejected. Thereafter, Lordship, we came before your Lordship. And Lordship has observed, as he has rightly pointed out, that Lordship on the last occasion observed that victim should be examined. But our sole contention in the case, Lordship, since Lordship's rejection, Lordship may see that 22/7, that is July, August, September, October, November, December, 6 months, Lordship. And since Lordship rejection, no witness, in spite of receiving the summon, Lordship, from the court, she did not turn up before the court, Lordship. She has
on what
not-
basis you are saying in spite?
Saying, Lordship, even she has received this notice also from High Court, Lordship. She has not appeared here also,
No, that is a different issue.
Lordship. And that is my instruction, of course, nothing. And here, Lordship, the basic part of the
When is the next date fix?
the next date fix, I just have to take one more instruction.
Next date is Lordship.
Thank you.
10/11/2025.
That is not
Because
the, that is
of,
the last
last-
day. When is it is fixed next?
There is no, then this court, they
You
have
find
sent
out.
it to this court.
Just find out,
You find out
Moreover,
when is,
another thing I want to point out, Lordship.
Lordship.
Respondent has also been there from the petition, respondent number side, Lordship, apart from the amicus curiae.
you have objection?
My lord, allegation is serious, my lord. When the incident took place, where she was 15 years old, my lord. My lord,
No, why have you not appeared before the trial court for educing your,
that instruction I have not received, my lord. When that was fixed, in
take
trial-
that instruction.
trial court, my lord. My lord,
Whether you have received summons
yes, my. Yes, I will take the instruction.
and you also take, when is the next date fix? We'll take it up after some time. At 2.
Yes.
2 it is okay. Or after some time,
Or
After some time,
Will be better, Lord.
after some.
after some time.
at 12.
No, Lordship. Or it may be taken up tomorrow, Lordship.
Okay, tomorrow.
Tomorrow.
Because what I intend to do,
At 2.
No, no,
Tomorrow I will not available, my lord. Tomorrow I will not be available.
no,
So sometime.
what I intend to do, suppose the date is next fix in the month of December or January, then we'll direct the trial court to examine the victim on that day and take up this matter after that date. And suppose you get instruction that in spite of receipt of summons, she has not appeared, then we may consider.
Tuesday court বন্ধ হতো না একদিন কালি লাস্ট ওয়ার্কিং ডে কালি কালি হেৰি my instruction খালি প্লেস কৰিম instruction টো Instruction place the agreement. Let it be tomorrow, Lordship. I'll place the instruction only.
Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor, as well as Mr. B. Puragohai, appearing for respondent number 2, as well as Miss M. K. Brown, learned amicus curiae. On request of learned
Lordship,
A,
I have seen Lordship, next date is today, 18/12.
then find out tomorrow whether today victim has been examined. Today victim might be examined. Tomorrow, let this matter be listed again tomorrow. Then that is on 19/12/20.
I'm obliged.
A victim gets examined today, there is a possibility.
Obliged.
Obliged.
27 and 38 from supplementary list.
May I please tell Lordship? Lordship, today fixed for the whole case diary from the,
I have seen in the order sheet, Lordship, as per order sheet number, Lordship, 17/12, it has not received. Lordship may look into that.
Whole case diary is
Not received, as per the office note, Lordship.
it is regarding their presence at this spot. This is a case of mob lynching.
present Lordship, but involvement and present is different Lordship. Maybe only statement of the co-accused Lordship. And TIP not identified the accused person. 37 and 38.
No, we have to go through the entire
Lordship.
case diary. There is one more case. Heard Mr. M.A. Mondal,
K.R. Bora, Lordship.
heard Mr. K.R. Bora.
38.
You are in item number
38.
and in 37,
M.A. Mondal.
in 37, 38 separate orders above of same, only change the nature, name of the council. In 37, heard Mr. M.A. Mondal, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. It appears from the office note that the scanned copy of the entire case diary, which was called for from the Court of Learned Additional Session Judge Jorat, has not yet been received. Registry to issue reminder for this scanned copy of the entire case diary. The trial court should ensure that this and scanned copy of the entire case diary should reach this court before the next date fixed. 7th of January. Let this same order in next case. Counsel's name will be K.R. Bora.
Order item
Obliged.
41. Item number 41.
There are also Lordship, also case. Scan copy also not received, Lordship. And it was respondent number 2 was notice was sent to registered post, Lordship. It has also not received.
We'll take it up after something. After something.
So item 5.
My lord, may I kindly take it up after some time. Senior counsel Mr. Saibal is on next.
Okay, we'll take it up after some time.
My
In this appeal, my lord, we had challenged the order dated 28/6/2024. Passed in missed arbitration case number 33 of 2024. Now, my lord, that revision petition, my lord, the arbitration petition under section 9 itself has been withdrawn for lack of jurisdiction. So matter has become.
This has become infructuous. Heard Mr. P.J. Soikia, learned senior counsel assisted by Mr. A.J. Soikia, learned counsel for the appellant. Learned senior counsel for the appellant has submitted that this appeal under section 37 within bracket 1 within bracket B of the Arbitration and Conciliation Act 1996 has been preferred by the appellants, impugning the order dated 28/6/2024 passed by the Court of Learned Civil Justice Senior Division number 2, Kamrup in Miss Arbitration case number 33/2024. Stop. However, he submits that the aforesaid Miss Arbitration case number 33/2024 has been withdrawn,
Disposed of on withdrawal.
has already been disposed on withdrawal. You have withdrawn the
Withdrawn the arbitration.
already disposed of on withdrawal. And therefore the instant arbitration appeal has become infructuous. Stop. Learned Mr.
M. Sahiwala.
M. Sahiwala, learned counsel for the respondent, has also confirmed, has also agreed to the submissions made by learned senior counsel. Accordingly, this arbitration appeal is dismissed on becoming infructuous, disposed of on becoming infructuous. In view of the order passed in the connected arbitration appeal, this interlocutory application is also disposed of.
Item 5.
My lord, here I am challenging an order by which, my lord, the certificate of the salary has been termed as a public document. You can also see, my lord, the impugn order at page 68.
No, why this IA is there?
I am, my lord, for interim order. Interim is there, my lord.
CRP Ayodhya.
Dispose, it can be disposed of, my lord, no problem. Because already, my lord, interim order was passed.
We'll take up the IO and the CRP.
Yeah, yes. Finally, my lord.
Yes.
If a losses comes to my lord, page 68, my lord, the impugn order.
Page 68.
60 plus. Small order, my lord, 2 pages.
Yes.
The fourth paragraph. The instant petition filed by the learned counsel for defendants is specifically regarding permission not taken from this honorable court for the purpose of relying on a document marked as Exhibit 2 in the evidence of affidavit supported by PW1, that is plaintiff. The observed that the said document is a certified copy of the sale deed that is so and so. It's important to note that there is no dispute regarding the genuineness of such document as it has been admitted by the defendants in their written statement itself. It is further observed that said document was filed by the plaintiff side at the time of filing of the plaint, but there was no objection rendered by the defendant side at that particular period of time. It is observed that the instant case in all pending case pending for a period for more than 10 years for cross-examination of PW. It is to be noted that in this case, the plaintiff, PW1, is a resident of New Delhi who came on 9/9/2004 for recording his cross could not be conducted due to filing of the instant petition. The document, as aforesaid, comes within the purview of the definition of public document as per section 74 of the Indian Evidence Act. Madam, this is wrong, madam. This is not correct. Further, section 77 of the Act provides that the contents of public document or any part thereof, it may be proved by production of the certified copies. And under section 79 of the Act, the court shall presume such document to be genuine. Thus, the law is very clear that pertaining to public document, its contents may be proved by production of certified copies for which no permission is required to be taken from this honorable court, as stated by the petitioner in this petition. In view of the aforesaid discussion, interest justice that to prevent the petitioner from filing this kind of petition in a case for more than 10 years old, that too at the time of prosecution of the appeal, the court deems fit to reject the instant petition by imposing a cost sanction.
What was your petition? Where is your petition?
Petition, my lord, yes. My lord, that is that page, my lord, 66. At page 63, my lord. The evidence on by affidavit of the plaintiff is on record, and the PW is required to face the cross-examination of the defense counsel. That in the said affidavit, evidence PW1 relief relied on exhibit 2, which is a certified copy of the deed of conveyance, that so-and-so, being number so-and-so. That as required under law, PW1 did not pay for permission from the honorable court to rely on a secondary evidence. Hence, the evidence of PW1 goes being not maintainable, untenable by education in the law. It is therefore paid for. Well, this is what I'm saying. Well, because when they you say secondary evidence, my lord, they have to call for the primary evidence first. They have to establish it. Like that. But in this aspect, well, there are various judgments of the Supreme Court. That so far salary is concerned, it's not a public document. One of the my latest, my lord, judgment I can place, my lord, before lawsuits. My lord, that is 21/4/6786. Earlier judgments are also there, my lord. 786.
What is the citation?
Paragraph 22-23, my lord. At page 812. Paragraph 22, my lord, is subpara, my lord, which is quoted from the earlier judgment. Maybe just.
Para?
Para 22. Here they have quoted the judgment of the earlier, my lord. You also got it, my lord. Para 22. Left hand side, my lord.
Yes.
Well, this subpara may be seen, my lord. They quoted. It is online. Deed of sale is a conveyance. A deed of conveyance or other document executed by any person is not an act nor record of an act of any sovereign authority or an official body or tribunal or any public officer, legislative, judicial, and executive. Nor it is a public record kept in the state of any private document. A sale deed or any other deed of conveyance, when presented for registration under the Registration Act, is not retained or kept in a public office of a state after registration, but it is returned to the person who presented such document for registration. on completion of the process of registration. An original registered document is not therefore a public record kept by the state of a private document. Consequently, a deed of sale under a registered document will not fall under either of the two classes of documents described in section 74 as public document. Any document which is not a public document is a private document. We therefore have no hesitation in holding that a registered sale deed is not a public document but a private document. This position is made abundantly clear by Gopal Das versus so-and-so, it's a private council judgment that reported. It was contended by Sir Thomas so-and-so for the respondent that the receipt comes within the para 2 of section 74 Evidence Act and is a public document. Hence, section 65E, no foundation is required as in the case coming within the clause A, B, C of that section. Their lordships cannot accept this argument since the original receipt is not a public record or a private document. The original has to be returned to the party. A similar argument will appear at one time has been some acceptance in India, but it involves misconception of the Evidence Act and Registration Act and later decisions abandoned it. We may refer to the following passage of Ratan Lal's Law of Evidence. Public document. This clause is intended to protect the original of the public document from the danger to which they would be exposed by constant production of evidence. Second, the evidence is admissible in the case of public document mentioned in section 74. What section 74 provides is that public record kept in any state of private documents are public documents, but private documents of which public records are kept are not in themselves public documents. A registered document, therefore, does not fall either in the clause E or F of section 65 of the Evidence Act. The entry in the registered book is a public document, but the original is a private document. Thus, the fact of registration what other private document inter partes does not plot the document with a higher legal status by virtue of registration. Also, it is remembered that Delhi High Court reasoning in the Sulochana Uppal that it is the court alone can, under the Special Relief Act, enforce a performance of an agreement is contrary to a reasoning of the Olympus overruling, stating that the dispute or difference which the parties to an arbitration agreement agrees to refer must consist of justiciable issue, tribal activity. Since the SCP performance of a justiciable issue for specific act, and this is not required matter, I think. So, this is the matter. Other judgments are there, matter. I'm just referring to two judgments more, matter. Are these judgments? 2004 7 SCC 107 and another is 1990 1 SCC 260.
You are mainly agreed with the admissibility of Exhibit 2.
Well, because they have to let the foundation as per section 65, my lord.
But this you can argue at the time of main argument of the case.
No, my lord, I cannot because this will be evidence now. They have exhibited. That cannot be exhibited, my lord, for foundation. Foundation must be there, my lord.
No,
Because evidence they have.
it may be allowed to be exhibited subject to objection, whether regarding the question of admissibility of the document
But that
at the
observation,
time-
my lord, that observation was
is not there.
should be, my lord, because it's not a public document, my lord. That observation has to be set aside in that case, and your losses may be delivered.
Yes, what is this case? Second one.
Yes, my lord. 13, 14, and 15, my lord. Well, we do not find merit in the civil appeal in the present case. The objection was not that the certificate, oh, sorry. Same thing, my lord, exactly same, my lord, same. Because this is not a public document. On this, my lord, both the judges are there. Same thing, I'm not, our High Court judges are also there now, same line.
No,
Well,
whether the exhibit 2 is admissible or whether it can be relied upon by the trial court, that question may be agitated during the final argument because it has already been exhibited. If some clarification is given,
that can be done, my lord. Only thing, my lord, your lordship observe, my lord, this is not a public document as per statutory. That cannot be done. Because that observation has been made by the trial court, my lord, that this is a public document. So
yes, Mr. Singh.
My lord. Your lordship, I will take only 2 minutes, my lord. Kindly see whether the application is sustainable. Just for a moment, my lord. Kindly see the written statement. It starts at page 36, my lord.
Page 36.
My lord.
Yes.
And just to understand, my lord, before I refer to the written statement, my claim is that my father purchased the property and the present defendants are my cousins who happen to be the sons and daughters of my uncles. So my father and the present defendants whose father or whose husband were both brothers, my lord. My father and the husband or father of defendants. Now the property was purchased by my father way back in 1961. And I have referred to from whom the property was purchased in paragraph 4 of my plaint. Amit Basu. I have already stated from him the property was purchased. Now what is their reply, my lord? Kindly come to para 1. There is no cause of action for the suit. Admitting that late Gauri Shankar Himmat Singh purchased the suit land in 1961 from original owner, that is Ajay Kumar Basu, son of late Jyotish Kumar Basu, through a registered sale deed number 1173 of 1961. So through written statement, the defendants admit that my father had purchased the property in 1961 from Mr. Basu. That admission is there.
This purchase was by virtue of
By
this
way of a registered sale.
exhibit. This
Now,
exhibit.
Exhibit 2, my lord.
Exhibit 2.
Exhibit 2 is a certified copy of the sale deed. Now, whether the primary evidence required to be exhibited, first, when the original sale deed was in the hands of my uncle, that is the husband and father of defendants. I have already stated in my plaint in para 4 that the original was always kept by my uncle, not by my father, because my uncle was looking after the property, because there was no dispute between the two brothers. So before I move, my lord, to the legal proposition, kindly have a look at para 4 of my plaint. Plaint starts, my lord, at page 24. And para 4, my lord, is at page 26 and 27. May I read, my lord?
No, what you want to emphasize?
That my father had purchased and the original sale deed was in the hands of my uncle. That is the husband.
That you have pleaded in your plaint.
My lord. Kindly have a look at para 4. Father of the plaintiff, late Gauri Shankar Himmat Singh purchased the suit land measuring 1 Katha 9 Lasa, situated at NT Road, Maucha Mahabhairav, PO and PS Tejpur, District Sonitpur, Assam, which is more fully described in the schedule below from one Ajay Kumar Basu, son of late Jyotish Basu, through a registered sale deed bearing so and so. The father of the plaintiff mutated his names in the records of right. On the land, an Assam type house was built where in the front portion a shop in the name and style as Messrs. Himmat Singh Auto Enterprise was run, and in the back portion there were rooms where late Gauri Shankar Himmat Singh and his brother, late Santosh Kumar Himmat Singh, used to stay during their stay at Tejpur. The land was then covered under Dag number so and so, Patta number so and so. The land documents were mainly looked after by late Santosh Kumar Himmat Singh, the predecessor in interest of the defendants. This we have clearly mentioned. Now, in response to this, my lord, in the written statement, there is admission that yes, it was Gauri Shankar Himmat Singh who had purchased through a registered sale deed. Now, kindly come to section 65, my lord, of Evidence Act. This will clarify.
Putul, Evidence Act. Yes, you read.
Your lordship will recall that their application is under section 63 of Evidence Act, challenging the submission and exhibition of certified copy of the deed of sale. That is their concern, that why not the original sale deed has been produced. So in para 4, I have made it clear that it was the custodian of this original sale deed was Mr. late Santosh Kumar Himmat Singh.
But the petitioner are aggrieved because of the observation made by the trial court that the sale deed is held to be a public document.
This dispute is still an ongoing dispute, my lord. So before I refer section 65, may I refer one of the Supreme Court latest judgment of 2023, my lord?
Regarding
what is the nature of sale deed, my lord. Just for a clarification, my lord, and this dispute since Privy Council's days is going on, I am referring to one judgment of 2023, my lord, Supreme SC page 974. In the case of Andi Muthu versus Elias Thanga Pandi. Priyanku, kindly hand over the judgment to Honorable Court.
Yes.
My lord, kindly come to para 21.
Yes.
Section 74 deals with documents which are public documents. Subsection 2 thereof makes public records kept in any state of private documents within the purview of public document under section 74. Going by section 76, certified copies of public documents shall be given on demand by the public officer having the custody of public document, together with a certificate written at the foot of such copy that it is true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title. Such copies so certified shall be called certified copies in terms of section 76. Now, my lords, what is public private document which has been kept by public authority? Those have been briefly stated in para 21. Now kindly come to para 22. It is to be noted that in the case on hand, a certified copy of exhibit A1 sale deed dated so and so was produced by the appellant. As noted earlier, the courts below found that it is registered with the sub-registrar office. The contention of the respondent that it is only a certified copy and not the original document. In the light of aforementioned provisions under the Evidence Act, there can be no doubt with respect to permissibility for the production of such a certified copy as secondary evidence in law in regard to existence, condition, or contents of a document. As per section 77 of the Evidence Act, such certified copies may be produced in proof of the contents of the public document concerned. Section 79 deals with presumption as to genuineness of certified copies. Such section 77 and 79 of the Evidence Act read thus as under, and thereafter the section has been reproduced. Next para, the court shall presume that any officer by whom any such document purports to be signed or certified held, when he signed it, the official character which he claims in such paper. Now, Your Lordship, the gist of this entire discussion is that a sale deed was before the Honorable Supreme Court. And Honorable Supreme Court, while dealing with the sale deed, said that it is nothing but a record of private document kept in public record by the state government. So this dispute is still going on, my lord, whether a sale deed is a public document or a private document kept in a public office, my lord. Now, kindly come to section 65, my lord, whether this dispute or subject is at all relevant for the present case, my lord. Section 65 of Evidence Act. Cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents of a document in the following cases. A. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or of any person out of reach or not subject to the process of the court, or of any person legally bound to produce it. And when, after the notice mentioned in section 66, such person does not produce it. I pause for a moment, my lord. Section 65A, if it is read, it makes it clear that so far notice under section 66 is concerned, it is only applicable when a document which falls within the ambit of A of section 65, a notice is mandatory, my lord, under section 66. Now kindly come to B. When the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. Now, what does B say, my lord? When the original or its contents has been admitted against whom it is intended to be used. In my case, my lord, the defendant, through their written statement, have made a very categorical statement that they do admit the existence or the purchase of the property by way of a registered sale deed by late Gauri Shankar Himmat Singh. The moment they admit it, is there any necessity of myself proving? Answer is no, my lord. I kindly come to same section, my lord, after G. In cases A, C, and D, kindly take note, my lord. The provision relates to A, C, and D. Any secondary evidence of the contents of the document is admissible. In case of B, the written admission is admissible. Now, in my case, my lord, I am not even required to exhibit the sale deed, be it the original or the certified copy, because there is a categorical admission. So far B is concerned, my lord, under section 65, if there is a categorical admission, written admission itself is sufficient. Am I clear, my lord? May I proceed to other provision? This same section, my lord, in case of E or F, a certified copy of the document, but no other kind of secondary evidence is admissible. E and F would have been applicable in my case had there been no admission in the written statement itself. So since my case comes under 65B.
Your submission is that even if the exhibit 2 is not admitted, your submission is that you are not even required to produce exhibit 2 in view of the admission made by the petitioners in their written statement.
So, my lord, in another way, I want to say that 65B I have complied, or there is compliance even by the other side. They have admitted about the purchase of the property by late Gauri Shankar Himmat Singh in 1961 from Mr. Basu. Now, after having admitted whether I am submitting the original or the certified copy, does it make any difference to them? No. So unnecessary, they have raised a question which legally they cannot do. Now kindly come to section 66 for a moment, my lord, of Evidence Act.
Yes.
Secondary evidence of the contents of documents referred to in 65 clause A shall not be given unless the party proposing to give such secondary evidence has previously given to the other party in whose possession or power the document is, or such notice to produce as is prescribed by law. And if no notice is prescribed by law, then such notice as the court considers reasonable under the circumstances of the case. So only in case of 65A, if someone wants to lead secondary evidence, then a notice must precede prior to leading the secondary evidence.
Yes.
This is not applicable when proviso A1, when the document to be proved is itself a notice. 2, when from the nature of the case, the adverse party must know that he will be required to produce it. 3, when it appears or is proved that the adverse party has obtained possession of the original by fraud or force. I have already stated in my plaint that was always in the custody of late Santosh Kumar Himmat Singh. When the adverse party or his agent has the original in court. 5th, when the adverse party or his agent has admitted the loss of the document. 6, when the person in possession of the document is out of reach. So far myself is concerned, my lord, 65B does not contemplate issuance of any notice because of the fact that there is an admission by the other party. So A, C, D, E, F, G doesn't apply in my case, my lord. That is my humble submission. So for the other provisions, my lord, which Learned Senior was referring to, section 74 or 78 and 79, my lord, those are not applicable, especially in my case. My brother is saying that it's a sale deed, and sale deed is not a public document, it's a private document. Whether this dispute or this debate is necessary in my case because of the fact that there is an admission by the defendants and the existence or the execution of the document has been admitted, my lord. So as an abundant caution only, we submitted the certified copy and we exhibited it. That is my humble submission.
Okay.
So, my lord, 3 judgments before my learned brother intervenes. There are 3 more judgments on which I place my reliance. This is fact, my lord, that a trying magistrate has the power to deal with an issue that has been raised before the court. Now, an application was submitted under section 63 of Evidence Act. Now, the court, while dealing with the application and taking into account our objection, rejected the application. Whether there is any sort of perversity, if not, then Article 227 cannot be invoked in such a manner as has been done by the other side, my lord. Now, in this regard, because, my lord, these questions can always be raised under Order 43 by way of an appeal. Suppose, as your lordship was pointing out, during the course of the final argument, this issue could have been agitated and raised. And even if the answer would have been against the other party, they could have raised it in appeal. Instead of doing that, rushing to the Honorable High Court, invoking its power under Article 227 is not acceptable, my lord. May I refer to 3 judgments?
Refer only one.
My lord.
You refer the best
It would
judgment.
have been pleasure, my lord, to refer 3. Okay, my lord, I will be confining only to 2. 1, my lord, 2001, 1 SCC, page 97. Priyanku, kindly provide the judgment. 2001 SCC, page, volume 1, page 97,
Para 6 and 7, my lord.
there are 6 and 7.
I flag mark.
The scope, para 6, my lord, the scope and ambit of exercise of power and jurisdiction by a high court under Article 227 of the Constitution of India is examined and explained in number of decisions of this court. The exercise of power under this article involves a duty on the High Court to keep inferior courts and tribunals within the bounds of their authority and to see that they do duty expected or required by them in a legal manner. The High Court is not vested with any unlimited prerogative to correct all kinds of hardships or wrong decisions made within the limits of the jurisdiction of the courts, subordinate or tribunals. So even if we presume for argument's sake, my lord, that the judgment is erroneous or the observation are erroneous, but since it has been done within the parameters of law and the power was available either to accept or to reject the application, my lord, whether it can be said that the judgment is perverse. I further read the said paragraph, my lord. Exercise of this power and interfering with the orders of the courts or tribunal is restricted to cases of serious dereliction of duty and flagrant violation of fundamental principles of law or justice, where if High Court does not interfere, a grave injustice remains uncorrected. It is also well settled that the High Courts, while acting under this article, cannot exercise its power as an appellate court or substitute its own judgment in place of that the subordinate court to correct an error which is not apparent on the face of the record. The High Court can set aside or ignore the findings of facts of inferior courts or tribunals if there is no evidence at all to justify, or the finding is so perverse that no reasonable person can possibly come to such a conclusion which the court or tribunal has come to. Now, if you consider, my lord, the admission in the written statement, what is the error that has been made by the learned trial court? Para 7, this court in so and so in para 12 has stated that the power under Article 227 of the Constitution is intended to be used sparingly and only in appropriate cases for the purpose of keeping the subordinate courts and tribunals within the bounds of their authority and not for correcting mere errors. If you give me liberty, my lord, one more judgment in the same subject, that is to 2025 Supreme Online SC, page 25, paragraph 15. It is evident from the above that even as per the court herein above, interference under Article 227 is permissible only if the order is completely perverse, that the perversity must stare in the face. Now, if you consider, my lord, I am reiterating, if you consider the admission and also the fact that my case comes under Section 65B of Evidence Act, the whole debate that has been raised by the other side is unacceptable. My case doesn't fall under 65A or C, D, E, F, G. It comes under B, and there is categorical admission by the other side. So whether I am submitting the original or the certified copy, it doesn't make any difference to either of the party. And it is only as an abundant caution, my lord, so that my record remains available to the learned trial court while disposing my suit, that we have provided the certified copy of the CD. That much. I am deeply obliged.
One more judgment, my lord. It's regarding only one more judgment, my lord, regarding here, my lord, 2020 judgment, my lord. Here, my lord, Apex Court has held that, my lord, if documents is admitted, my lord, no leave is required, my lord. It's kindly come to paragraph 19, my lord. 19 and 22, my 19 later part, my lord. last few lines, 5 lines, my lord, the plaintiff had admitted. Paragraph 19.
Yes,
The plaintiff had admitted the execution of the will, though it was alleged to be the result of fraud and misrepresentation. The execution of the will was not disputed by the plaintiff, but only proof of the will was the subject matter in the suit. Therefore, once the evidence of the defendant is that the original will was lost and the certified copy is produced, the defendants have made out sufficient ground for leading secondary evidence. Then, my lord, directly come to paragraph 22, my lord. Here, my lord, Apex Court has held that there is no requirement that an application is required to be filed in terms of section 65C of the Evidence Act before the secondary evidence is laid. A party to the lease may choose to file an application which is required to be considered by the trial court. But if any party to the suit has laid foundation of leading of secondary evidence, either in the plaint or in evidence, the secondary evidence cannot be ousted for consideration only because of an application for permission to lead secondary evidence was not filed. Categorically held, my lord, which has been stated by MS Senior Counsel, my lord.
okay. Heard.
My lord, only thing, my lord, that I submit that my learned friend is wrong that 23 judgment, that is 2 judges judgment, but 21-4 is, my lord, 3 judges. That has already been held, my lord, that is not a public document. I am only on that, my lord. As your worship said, my lord, that will be considered at the time of argument.
Heard Mr. G. N. Sahewala, learned senior counsel, assisted by Mr. H.K. Sharma. Also heard Mr. S.K. Singh, learned senior counsel, appearing through video conferencing and assisted by Mr. P. Sundi, learned counsel for the respondent. This learned counsel for the respondent. This application under Article 227 of the Constitution of India has been filed by the petitioners, namely Rama Devi Himmat Singka, Rajesh Himmat Singka, and Rajesh Himmat Singka, impugning the order dated 11/9/2024, passed in title suit number 72/2014 by the Court of Learned Civil Judge Junior Division number 2, Sonitpur, Tejpur, whereby the application filed by the present petitioners under Section 63 of the Indian Evidence Act was rejected, and the respondent was allowed to exhibit the sale deed number 1173/1961 dated 24/12/2013 as Exhibit 2. Stop. The facts relevant for consideration of the instant civil division petition, in brief, are that the present respondent has, how many respondents are there? Only one.
One.
The present, others are pro forma. Present respondent number 1, as plaintiff, had instituted a title suit, being title suit number 72/2014, title suit number 72/2014 for declaration of right, title and interest over the suit premises, and for relief that the mutation of defendant number 2 and that of his father in respect of the suit property is illegal. Stop. Learned senior counsel for the petitioners has submitted that in the aforesaid suit, the respondent exhibited a certified copy of the sale deed number 1173/1961 dated 24/12/2013.
My lord,
Yes.
correction may be required, my lord. That is
Yes.
the date on which the certified copy was made available to me. The actual date of sale is 28th of August 1961. This is the date on which certified copy was made available.
Oh, so it is wrong. It is wrongly mentioned. It is apparent. The date of sale deed is
28th of August 1961.
28th of August 1961. पहले भी date change कर देना. 28th of August 1961. Learned counsel for the petitioner, learned senior counsel for the petitioner submits that since the original sale deed was not produced by the respondent number 1 before the trial court, hence the present petitioners had filed an application under section 63 of the Indian Evidence Act objecting to the admissibility of the said sale deed without following the requirement as prescribed under section 65 of the Indian Evidence Act. Stop. Learned senior counsel for the petitioner has submitted that, however, by the impugned order, the trial court held that the exhibit 2 to be a public document and therefore erroneously held that there is no requirement of fulfilling the norms laid down in section 65 of the Indian Evidence Act before admitting the said documents. Sale deed. Learned senior counsel for the petitioner submits that the trial court had erred in making in holding that the sale deed which is exhibited as exhibit 2 is a public document. He submits that the apex court, which is the judgment which you are relying?
21, my lord. That is a three judges bench, 21 for SCC 786. Paragraph 22, my lord.
Last line. He submits that the apex court in the case of Deccan Paper Mills Company Limited versus Regency Mahavir Properties and others, reported in 2021 4 SCC 786, have categorically have very clearly held that a sale deed, which is a deed of conveyance is not a public document, but a private document. Stop. He there. Stop. Private document, stop. He relies upon the following observations made by the apex court in the aforesaid case. Quote para 22 from the aforesaid judgment. Learned senior counsel for the petitioners submits that in view of the aforesaid observations made by the apex court in the aforesaid case, there remains no doubt that the observations made by the trial court in the impugned order is contrary to settled proposition of law, and hence he submits that the impugned order is liable to be set aside. On the other hand, Mr. S.K. Singh, learned senior counsel for the respondent, has submitted that the document that the sale deed which has been exhibited, which was exhibited by the present petitioner in the aforementioned title suit as Exhibit 2, has already was executed by whom it was
Ajay Kumar Basu, my lord.
was executed by one Ajay Kumar Basu in favor of the
Late
father,
Gauri, father of the present
father of
respondent.
the present respondent number 1, namely late Gauri Shankar Himat Singh, and the aforesaid sale deed is in possession of the present petitioners as the land documents in respect of the scheduled land was looked after by the predecessor in interest of the present petitioner, namely late Santosh Kumar Himat Singh. He further submits that the present petitioners have also admitted in their written statement filed before the trial court in the aforesaid suit regarding the fact that late Gauri Shankar Himat Singh purchased the suit land in 1961 from the original purchaser, namely Ajay Kumar Basu. He further submits that in view of the clear admission of the existence of the sale deed, which was exhibited as Exhibit 2, the petitioners, no, the respondent case is covered under section 65 within bracket small b of the Indian Evidence Act 1872. And as such, for Indian Evidence Act 1872, stop. He further submits that in view of the clear admission of the execution of this failed deed by the in favor of the predecessor in interest of the present respondent number one, the respondent is even not required to adduce any secondary evidence to that effect in view of clear admission to that effect in the written statement filed by the present petitioners. He also submits that the requirement of issuance of notice under section 66 is also section 66 of the Indian Evidence Act is also not there in view of the clear admission of the existence of clear admission made by the petitioner in the written statement filed by them before the trial court. He also submits that learned senior counsel for the respondent further submits that as regards whether the sale deed executed by private persons is a public document or not, the question is not yet settled as which judgment you have.
2023, Supreme Court 974, madam. That is page, paragraph 20 and 22. 2023, madam. Supreme Court 974. Appaya versus Andimuthu, madam.
Illegal last name. Not yet settled as what was your submission regarding the Mr. Singh?
My lord, every alternate year we are coming across, this is the last judgment which I have come across prior to what my,
What has been observed in 21-22?
ultimately the Honorable Supreme Court was dealing with a certified copy of a sale deed and referred to it as a private document kept by the public authority, hence covered under section 74 of Evidence Act.
That is, it has been observed by the apex court in the case of Appaya versus Andimuthu alias Thangapandi and others reported in 2023 Supreme SC 974 that a sale deed, a private sale deed kept in public no, repeat what you have said.
Sale deed, which is a private document but kept and maintained by public authority, is covered under section 74.
That the sale deed
becomes a
which is
public.
kept and maintained by the public authority is covered under section 74
Subsection 2 of Evidence Act.
within bracket 2 of the Evidence Act.
Not referring to teacher's expenditure.
No,
Don't
I am
refer-
only reflecting his submissions. He further submits that what was the last judgment, Mr. Sundi,
Last
which you,
judgment is my 2020 16 SCC 209, my lord. Dhanpat versus Shivram. my lord. Paragraph 19 and 22, my lord.
he further submits that there is he further submits that if any party to a suit has laid the foundation of leading secondary evidence either in plain or in evidence, as has been done by the respondent in his case, there is no requirement that an application under section 65 of the Evidence Act has to be filed separately by such a party. In support of his submission, he has also cited a ruling of the Apex Court in the case of Dhanpat versus Shivram through legal heirs reported in 2020 16 SCC 209. He submits that by pleading the existence of the sale deed which has been exhibited as Exhibit 2 in the plaint, the respondent number 1 has laid the foundation for exhibiting the said sale deed as Exhibit 2. He more so when the said fact has not been controverted in the written statement filed by the present petitioner. Rather, they have admitted the execution of such a sale deed. Learned senior counsel for the petitioner has further submitted that the impugn order has been passed by the trial court in exercise of well within the powers and jurisdiction exercised by the trial court after giving opportunity of being heard to the present petitioners, and therefore the in the instant case there is no dereliction of duty or flagrant violation of the fundamental principles of law by the trial court while passing the impugned judgment, justifying the invoking of supervisory jurisdiction by this court under Article 227 of the Constitution of India. He submits that even if it is assumed that this observation made by the trial court is erroneous, however, it cannot be regarded as perverse. And therefore he submits that the invoking of supervisory jurisdiction by this court under Article 227 is not called for. In support of his submission, he has learned senior counsel for the respondent has cited a ruling of the apex court in the case of Estrella Rubber versus Das Estate within bracket P Limited reported in 2001 8 SCC 97. Eight SCC 97.
Paragraph 6.
He further submits that as the impugned order cannot be regarded as a completely perverse order. Hence, the invoking of supervisory jurisdiction under Article 227 is not justified in view of the observation made by the apex court, the case of Serosoft Solutions Private Limited versus Dexter Capital Advisory Private Advisors Private Limited, reported in 2025 Supreme Online SC 2025. When is the next date fixed?
It
Is there any stay?
Stay.
It is stayed.
Statement.
I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. I have also gone through the rulings cited by learned counsel for both sides. First week of January. I'm reserving it.
My
Both side likhi. Hearing concluded, order reserved.
deeply obliged.
That may be recorded, my lord, our judge, my lord, the 23 judgment is par infinitum to item 21, my lord, because without referring to the key judgment, this one, my lord, that
In reply, the learned senior counsel for the, in reply to the submissions made by learned senior counsel to the, for the respondent, learned senior counsel for the petitioner submits that the observations made by the apex court in the case of
Appaya versus Unlimited.
Appaya within bracket Supra to the extent may be contrary to, appears to be contrary to the observations of the larger bench of the Supreme Court made in the
Deccan paper mill.
case of Deccan Paper Mill Supra, and therefore
Par infinitum.
same may not be binding on this court.
My lord, may I add one sentence, if you permit? Only one sentence, my lord.
Yes.
My lord, so far the sale deed its a status, whether it is a private document kept by the state government as a public document. I am not into that debate, my lord.
Yes, yes.
My
yes.
case is simply covered under 65B. And if your lordship reconsiders the fact that 65 starts with a small a to small g, so far B is concerned, the written admission itself is sufficient. That is the language.
Actually, what is my understanding is 65B enables you to adduce that written admission as an evidence. There
My
is
lord.
no necessity of
Further
producing any
proving.
secondary.
Because admission, once it is admitted, section 57 of
Okay,
Evidence Act.
that I will consider in my judgment.
Obliged.
Much
Obliged.
In January.
Much obliged.
Case বিলাক বেলেগ ফাইলত not in my.
May please, your lordship. Lordship, statutory appeal lordship preferred under section 23 of RCT Act 1987.
Miss, what is the name?
Lordship,
J.
Facebook.
J. Burua.
Lordship.
J. Bej Burua. Learned counsel for the appellant. Also Mr.
CKS Barua.
C.K. Sharma Burua.
CKS. Oh, yes.
C.K. Sharma Burua. Learned Central Government Council. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellants, impugning the judgment and order dated 29/11/2024 passed by the Railway Claims Tribunal Guwahati Bench in original application number Roman 2 dash 36/2020 Roman 2 small u dash 4/2024. The appeal is admitted. Since Mr. C.K.S. Burua has appeared for the sole respondent, no formal notice need to be issued to the respondent. You have received the memo of appeal. Stop. This appeal is admitted. Let the records of the original application, aforementioned original application, be called for from the Railway Claims Tribunal. Registry to take steps for requisitioning the records. Let this matter be listed after 4 weeks on receipt of the records from the.
Possible.
Obliged.
For hearing under order 41, item 9.
Some more time may be granted in this case. It may be posted after mark being.
Heard. Mr. K. Rahman, learned counsel for the appellant. He submits that he may be allowed some more time to respond to the queries posed by this court on 15/12/2025. Prayer is allowed. Let this matter be listed on 30 January.
Obliged.
As per the order of this honorable court took step from the respondent number 2. So, my lord, office note dated, my lord, 15 12/2025. The service is awaiting, my lord. So let it fixed on 29th of January.
Heard Mr. R.C. Paul. Learned. When have you taken steps?
I've taken, my lord,
Learned counsel for the appellant. On perusal of the office note dated 15/12/2025, it appears that the notice issued to respondent number 2. What happened to respondent number 1?
one is appeared in council.
Notice issued to respondent number 2 has not yet returned. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by registered by speed post on the next date fixed. Let this matter be listed again on 29 January.
Much. My lord, I am here, my lord.
My lord,
That's one over
during
three.
the pendency, the appellant has been expired, my lord.
Appellant is expired.
I pray that I may be allowed to file an application to implement
Okay.
the son.
Heard Miss T. Wapangla,
My-
learned counsel for the appellant. Also heard Mr. R.C. Paul,
That's one over three.
learned counsel for respondent number
Three.
3.
United.
Stop. Learned counsel for the appellant has submitted that during the pendency of this MAC appeal, the appellant has expired and therefore she prays for some time to take appropriate steps for substituting the legal representatives / heirs of the deceased appellant. The prayer is allowed. Let this matter be listed after Bihu vacation. You want a fixed date? After Bihu vacation on a date to be fixed by registry.
Like,
12. 8:30.
Yes.
My lord, we had filed an IA for implement of the owner and driver. Accordingly, the court was allowed to implement the respondent number 134.
234.
234. And after implementing that OP number 234, the court was not directed to issue notice.
You have to point it out to the court. It is your case. Suppose there is no direction. You have to assist the court. You have to point it out. Because it is a case of 2021. Now you take steps.
Yes.
I'm appealing for respondent number 1 now, Lordship.
Heard Mr. B.R. Das, learned counsel for the appellant. Also heard Ms. M. Chaudhary, appearing for respondent number 1. It appears that no notice has yet been issued to respondent number. No steps for issuance of notice upon the other respondents have been taken by the petitioner, appellant. The appellant is therefore directed to take steps for issuance of notice on the respondent number 2, 3, and 4 by speed post within 7 days of the date of this order, returnable after 4 weeks. List accordingly.
Just must oblige. Sir.
Item 13.
Right, please, Lordship. Lordship, can you see office note dated 16/12/25?
Yes. It has not arrived.
Not arrived. It was sent on.
From where?
From Kamrup Metro, MSC
Atul.
2.
হয়তো ম্যাক আপিল সেকশন সুপ্রিটেন্ডেন্ট ফোন করিব ফোন কৰি এই MACT 2 সিরাজদারক ফোন কৰি রেকর্ড আনিম by next day. Heard Mr. M. Talukdar, learned counsel for the appellants. Also heard Ms. P. Borthakur, learned counsel, appearing for respondent number 3. It appears from the office note dated 16/12/2025 that in spite of issuance of reminder for sending the records of MAC case number 671/2015, same has not arrived. Issue fresh reminder to the concerned motor accident claims tribunal. The superintendent of concerned section of the registry, the AOJ of the concerned section of the registry is directed to telephonically inform the Sheristadar of Motor Accident Claims Tribunal number 2, Kamrup Metro, to send the aforesaid record positively to this court on or before the next date fixed. Let this matter be listed on 6th of February. 6th February
Of this
2026.
Your service is not complete upon respond number 2, Lordship. So Lordship may kindly allow us to take steps by newspaper publication.
Heard Mr. S.P. Sharma, learned counsel for the appellant. This, on perusal of the office note dated
4820.
4/8/2025, it appears that the notice sent to respondent number 2 has returned with a report that no such person was found in the given address. As such, learned counsel for the appellant has prayed for allowing the appellant to take steps for issuance of notice upon respondent number 2 by substituted mode of publication of the notice in the newspapers. Prayer is allowed. The appellant shall take steps for publication of the notice in 2 newspapers
So because it is a local address. It's
in
from Baksa. Yes, Kumari Tata, Tamulpur, Baksa.
in one newspaper which is circulated in the area where the address of the respondent number shown 2 has been shown. the date of appearance in the said notice shall be mentioned as 18th of February. List this matter after the aforesaid date.
Obliged.
Yeah, please, Your Lordship. On the earlier occasion, we were directed to take free steps on the respondent on the two new address furnished by us. But Lordship, from the reading of the office note dated 2011-2025, it appears that it has been informed by the village admin to the process server that this person is not residing here since the last 3 or 4 years. So I may be allowed to take free steps by way of paper publication.
Your husband or wife?
I'm the wife.
Affidavit has been filed and that is on record, Your Lordship.
Heard Miss P. Borthakur, learned counsel for the appellant. Also heard Miss P. Borua, appearing for respondent number 1, 2, and 3. Learned counsel for the appellant submits that in pursuant to the directions of this court, the appellant has taken steps for publication of the notice to respondent number 4 in the newspaper, and said notice has accordingly be published in how many newspapers? 2 local newspapers, that is the Assam Tribune dated 3/7/2025
And
as well as Janam Bhumi, Doinik Janam Bhumi dated 3/7/2025. She also submits that the appellant has also filed an affidavit in compliance thereof before this court. After considering the submissions made by learned counsel for the appellant and after going through the affidavit in compliance filed by the appellant as well as the newspaper annexed therewith, this court holds that the notices, that the notice to respondent number 4 is duly served. Stop. Only 4 respondents are there. Records have arrived or not? Stop. Let the records of the, this is an appeal against
Lordship, main grounds of appeal are that there was no valid policy on the date of accident, Your Lordship.
no appeal against the employees.
Compensation Act, Your Lordship,
Let
19.
the records of EC case number 10/2022 be called for from the Office of the Commissioner, Employees Compensation, Golaghat, the registry to take steps for requisitioning the aforesaid records. List this matter after receipt of the records.
Obliged.
Made to give up. There's a transfer petition Miller filed by the wife. Lordship.
Why it has come?
Wife has filed the transfer petition.
Why it has come in orders column?
Yeah.
Husband has appeared.
What sir, yes, I'm going to be the husband, my lord. I've only filed my objection, my lord. This matter be listed after vacation for admission.
Heard Mr. A. Lal, learned
I want to file my objection now.
counsel for the this is item number 20.
No, 17, man, 17.
Learned counsel for the petitioner. Also Mr. F.K.R. Ahmed, learned counsel for the respondent, who submits that the respondent may be granted some time for filing written
No, we have
objection,
already filed, my lord.
Already.
and the respondent has has already filed a written objection against the prayer made by the petitioner. And therefore, this matter may be taken up
For admission.
for hearing
Admission, lots of small matter. my lord.
or admission hearing.
Though I file objection, my lord, but I don't have any objection, my lord. If you also dispose it today itself, I don't have any problem, my lord.
We will dispose it of today.
Yes, my lord.
You are not objecting to transfer.
Transfer one proceeding is going on since he is my still wife, my lord. I initiated
Stop.
my divorce proceeding.
Stop. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Anuradha Gop, praying for transfer of FC Civil Case number 1079/2024. Which was filed by the respondent seeking divorce from the petitioner in the Court of London. Where it is pending,
Pending, my lord, Lord Principal Judge, Family Court, number 2, Kamrup Metro.
where it will go.
Teachful law, district just teachful law.
क्या लिखा मनमोहन last line?
Sonitpur.
Sonitpur law.
Learned Principal Judge, Family Court number 2, Kamrup Metro at Guwahati, to the Court of Learned District Judge, Sonitpur. On what ground you are seeking transfer?
There is one case is pending, my lord, before that.
Learned Counsel for the petitioner submits that the petitioner is presently residing at Sonitpur and she had already filed which case is pending?
125 proceeding.
One.
Filed a case under section 125 and filed a case seeking monthly maintenance from the respondent, and which was registered as
MR case number 34/2020.
MR case number 34/2020,
Yes, my lord.
20,
In the Court of Learned Judicial Magistrate First Class.
which is pending in the Court of Learned Judicial Magistrate First Class, Sonitpur
Tezpur.
at Tejpur. And therefore, he submits that it would be convenient for both the parties to appear in, it would be convenient for both the parties is if both the cases between the parties are taken up in a common district, that is at Tejpur. Learned Counsel for the petitioner respondent submits that though the respondent has filed a written objection in this case, however, he has been instructed that the respondent does not have any objection if the prayer of the present petitioner for transferring the FC Civil Case numbers 1079/2024 to the Court of District Judge Sonitpur is allowed. Stop. Considering the submissions made by the learned counsel for both sides, as well as considering the grounds stated by the petitioner in her transfer application, this transfer petition is allowed. The FC Civil Case number 1079/2024 is transferred to the Court of Learned District Judge, Sonitpur. The Principal Judge, Family Court number 2, Kamrup Metro, shall send the records of the aforesaid case to the Court of Learned District Judge, Sonitpur. At what stage it is pending?
Appearance, no. We have appeared, but
The
where?
District Judge Sonitpur shall proceed with the aforesaid case from the stage at which it is pending now. Since learned counsel since both the parties are represented before this court by their engaged counsel, hence they are directed to appear before the court of learned District Judge Sonitpur on 10th February, on 10th of February, before which, 10th of February, the Principal Judge Family Court, the learned Principal Judge Family Court number 2, Kamrup Metro shall ensure that records of the aforesaid cases reaches the court of District Judge Family Sonitpur before the aforesaid date. This transfer petition is accordingly disposed of.
Please, your lordship. Lordship, I have preferred this IA, praying for amendment in the cause and title of the applicant. And also paid for alteration and modification in the appeal value, lordship. Earlier, I have claimed for 13,38,481. Now, lordship, during the pendency of this appeal, the respondent had partly satisfied the decree. And the balance amount is now, lordship, 76,680.
Yes.
In the IA, lordship, I have taken this plea at paragraph 1, lordship, may kindly see, page 3.
Just a minute.
Earlier, the applicant lordship name is Messrs. Hiroya and Sons Private Limited, which is now converted and changed to lordship limited company, lordship. In this regard, I have also furnished a copy of fresh certificate of incorporation dated 18/7/2013, which lordship may find at page 9. This is the certificate of incorporation with regard to change in the name of the applicant company, lordship. Earlier it was private limited, now it comes to limited company, lordship.
No. Whether the provisions of law which you have mentioned, Order 41 Rule 3 is applicable to this case.
Lordship, I have also made this application under section 151 of the CPC, lordship.
Or simply Order 6 Rule 17 would be applicable. Amendment of pleadings. Because Order 41 Rule 3 is applicable only if the plaint is rejected or returned. I don't know. You must be, it is your. You have no objection.
No, my lord. I have objection, my lord.
Second
As
thing,
per judgment dated 31/3/2021, part by the London RCT, they filed with their appeal before the Honorable Court, challenging the impugned judgment on various grounds. During the pendency of this appeal, they filed execution petition before the RCT. And the railway, the Northeastern Railway, Jaipur, Rajasthan, paid payment as per the in compliance of the judgment part with the RCT on the incorrect distance and of rupees 3,58,778 in compliance of order dated 69/2002 passed by the execution court, which is evident from the my in counter affidavit, my lord. Already I annexed the document at page 122 by order dated 31/5/2024. Really has satisfied the degree, and the claimant appellant already accepted this amount. So, lordship will kindly see at page 122.
No, their claim is that an amount of rupees 76,000 is out.
Here, my lord, in this judgment, my lord, only two issues were decided by the RCT. One is for the payment of the incorrect distance. My lord, yes, in my counter affidavit, my lord, already the levy of terminal charge and wrong calculation of the net tariff and freight concessions, my lord. Two decisions decided. But two issues has been framed, and in addition to the above issue, there are some other issues like wrong calculation of the distance rate, which would be dealt separately in the instant common judgment dated 31/3/2021. The learned RCC decided issue number 1, terminal charges against the applicant, that's the present appellant. By observing various provisions of Railway Act, Railway Board circulars are reflected in internal page 7 to 14 of the common judgment dated 31/3/2021 and pages 27 to 36 of the memo of appeal. This the RCT decided the issue number 2, wrong calculation of the distance in favor of the applicant appellant by observing the railway administration admitting that freight was charged on 2324 kilometers. The correct distance would have been 2287 kilometers. As a result, the respondent is directed to correct amount and make due refund payment with a 6% interest from the date of this order as reflected in para 3 Roman 2 at page 39 of the memo of appeal and the internal page of 19 of the common judgment dated 31/3/2021. So far, it is pertinent to mention here that no such issue in respect of the grant of 35% concession on rock phosphate power was raised in terms of IRCA goods tariff 45 of PT volume 2 read with rate circular 25/2008 dated 13/6/2008 was neither raised by the applicant or appellant nor framed by the RCT, whereas the railway administration granted 20%.
This 76,000 which you are claiming against what?
Against the point of terminal charges.
So my
Whether terminal charges were directed to
Transport, that charge is rejected, Lordship. So that is why we preferred the appeal, Lordship, where we have claimed terminal charges as well as the graded concession, Lordship, 35%. Then
no,
if
whether
the-
they are entitled or not, that will be decided in appeal.
It said it in this appeal, when the learned RCT rejected their claim regarding the terminal charge and graded concession on the rock phosphate miner. So only the learned RCT decided this matter on the freight collected on a wrong distance and which to be corrected by the railway and directed to make payment of the correct distance.
Their claim, what I have understood that. Well, listen to me. First listen to me, only then you can answer to my query properly. Their case is that what was directed by Railway Claims Tribunal has been paid,
Yes.
but terminal charge was not allowed by Railway Claims Tribunal. And against that rejection, they have preferred this appeal. And they are still challenging that.
Terminal,
They are claiming that terminal charges.
that they may challenge, but in the IA, they have claimed the balance amount of 76,000 is totally incorrect, my lord. Since the terminal charge was not considered by the RCT, where this balance amount has been counted. So this petition is become a
Lordship, the amount 76,680 is with regard to terminal charge.
Where have you mentioned?
The IA, Lordship. Paragraph 6.
It is my humble submission, my lord. When terminal charge was not considered by the learned RCT, the question of the claiming the balance amount on account of terminal charge doesn't arise. If it is allowed by the RCT, they really they entitled to.
Where is the proposed amendment?
Submit, Lordship. Lordship, the case before the learned tribunal is the claimant had preferred an application for the refund of 6% rebate on NTR, 35%
6% rebate on,
NTR.
what is NTR?
That 6% will be calculated in the total freight amount, Lordship. And second is Lordship refund of terminal charges, and the third claim is 35% freight concession on fertilizer, Lordship. That 35% will be granted to the petitioner, to the applicant, based on the circular, Lordship. In the trial court, Lordship, the learned trial court have allowed the refund of 6% NTR as well as 20% graded concession on the commodity, Lordship, not 35%. And thereafter, Lordship, we have preferred this appeal, Lordship, in the High Court.
Where is the proposed amendment?
Lordship, in the execution application, there is a partial modification, Lordship.
No. The amendment which you are seeking in the memo of appeal. Yeah.
In the memo of appeal, Lordship.
In your application.
Para Roman 1, page 5.
In page 5, there is no Roman 1.
Lordship, page 6. Page 5 and 6 of the memorandum of appeal.
Heard, Miss, what is your name?
Well,
I'm sure.
Yes.
sorry to disrupt, madam. In this case, they are claiming of the type 35% concern wrong phosphate powder. This issue was not framed by the learned
Learned?
RCT. When the judgment has been passed on 31/3/2021, as a common judgment, this issue was not framed. So,
But 35% concession or
the
but they have been given 20% concession.
5%.
Yes.
But here, my lord, I already mentioned in my counter affidavit, my page 7, my lord. It is pertinent to mention here in that no such issue in respect of grant of 35% concession on rock phosphate powder was raised in terms of IRCA Good Tariff number 45 PT volume 2, read with race circular 25 of 2008 dated 13/6/2008 was neither raised by the applicant appellant nor framed by the learned RCT, where the learned administration granted 25% of the graded concession rate circular number.
Para, which para you are
Para H, my counter affidavit, my lord. In page, internal page 7, para H. For H. H, my lord. What you got it?
Counter affidavit.
Page 7. Continuous page 59
Page 7.
of internal page of the counter affidavit and continuous page is 59. Para H. This is 4H. Page 7, my lord. Counter affidavit in, my lord, counter affidavit in MFA 99 of.
No, in MFA.
MFA.
No, but we are considering only amendment application. Your merits, we will decide in the appeal later on.
Still also of my lord. My lord, see, in my humble prayer, submission is that, my lord, since the digital amount has been satisfied, which is already passed by the learned RCT by execution court by order dated 35/1/2024, when as per judgment of the RCT, when the degree has been satisfied and they have accepted this amount, my lord, Then, my lord,
No, but they are challenging the rejection of terminal charges. And
only one point, my lord. This graded concession of granting of the 35% of concession on rock phosphate powder, this issue was not framed. So they cannot challenge it here, my lord.
That is why we are in the IE
you
lordship.
take this plea in the appeal, main appeal.
Yes, my lord, in main appeal, my lord, I have filed this counter.
No, we are considering the
Family,
interlocutory application.
but it is covered by the honorable, judgment passed by the honorable court also. Terminal charge also rejected by the honorable court also.
That we will decide in appeal.
Yes, my lord.
Heard Miss, what is your name? M. Sharma, learned counsel for the applicant. Also heard Miss U. Chakraborty, learned senior counsel, NF Railways. NF Railways,
No. Similar, not Western Railway, not NF Railway, my lord.
not
Western Railway, Jaipur, Rajasthan.
learned senior counsel,
For the Northwestern
senior
Railway,
railway counsel,
Northwestern Railway, NWR.
appearing for the respondent. This application, this interlocutory application has been filed by the applicant / appellant in connection with MFA number, miscellaneous first appeal number 99/2021 by the praying for amendment of the memo of appeal. Memo of appeal. Stop. Learned counsel for the applicant has submitted that during the pendency of the aforementioned MFA, the applicant had preferred an execution petition and in the aforesaid execution petition, the refund of 6% of rebate on normal tariff rate, NTR. What is NTR? Normal tariff rate, and 20% of 20% rebate on single superphosphate powder was allowed, which was allowed by the Railway Claims Tribunal, has been realized by the present applicant. She, however, submits that since the applicant has also impugned the judgment of the Railway Claims Tribunal on the ground that refund of terminal charges was rejected by the Railway Claims Tribunal, as well as the rebate on single phosphate powder was not granted to the extent of 35%, but only to the extent of 20%. Hence, memo of appeal is required to be amended. Why name of the appellant is changed?
Annexure 9, lordship, may kindly say. Certificate of incorporation I have furnished, lordship. Their name is changed and converted to limited company. Earlier it was private limited company.
She further submits that during the pendency of the appeal, the name of the applicant / appellant has been page number
Page 9. Okay.
the applicant has been converted into a private limited company, and therefore name of the appellant in the connected miscellaneous first appeal is also required to be amended. On
Into limited company, from private limited to limited.
private,
In the original application, whatever their name was there, and they had received this declared amount on against that name. Now, during the pendency of the case, they are changing the name, my
No,
lord.
my lord,
The
in the
means the
execution order-
matter of the case is the same.
Lordship,
They are
in the
challenging the terminal charges which was passed earlier.
oh, you reserve something for main appeal. We are allowing this interlocutor. On the other hand, learned Senior Railway Council has opposed the proposed amendment sought for by the applicant on the ground that the impugned judgment and order has already been satisfied by the respondent side in what was the execution case?
Execution case number 007/2022.
In execution case number 007/2022.
Right.
In as much as the 6% rebate on NTR as well as 20% rebate on phosphate, superphosphate powder has been made by the respondent side,
And my lord,
has
they
been paid by the respondent side.
paid on the
She,
correct distance also.
she,
They were already paid the difference of the correct distance, which was collected on the wrong distance.
she further submits that since the impugned judgment had not allowed any refund of terminal charges, the question of balance amount of rupees 76,680 does not arise in this case. She further submits that since no issue was framed as regards grant of 35% of rebate on single superphosphate powder, the said proposed amendment may also not be allowed. I have considered the submissions made by learned counsel for both sides. Though this instant interlocutory application has been filed by the applicant under Order 41 Rule 3 of the Code of Civil Procedure 1908. However, this court is of considered opinion that said provision is not applicable in the instant case, as the question of applying the aforesaid provision will arise only if the appeal is not drawn up in the manner prescribed by the Code of Civil Procedure, and when it is rejected or returned to the appellant. In the instant case, the appellant has sought for the amendment, amendment of the memo of appeal on the ground that during the pendency of the connected MFA number 99/2021, a portion, the impugned judgment, to the extent it granted refund of 6% of rate of MFA as well as 20% of the rate as well as 20% off freight concession on single superphosphate powder has been made by the respondent side. However, she submits that. However, as the contention of the applicant slash appellant regarding refund of terminal charges is yet to be decided, as well as the rebate on single superphosphate powder at the rate claimed by the applicant slash appellant is yet to be decided. This court is inclined to allow the proposed amendment so that the issue raised by the applicant in her in the memo of appeal may be decided properly. Stop. Accordingly, this interlocutory application is allowed. The applicant is directed to submit the amended memo of appeal with an advance copy thereof to the learned counsel for the respondent side on or before the next date fix. Let this matter be listed on 6th of February. This interlocutory application is accordingly disposed of.
As per the office note dated 25/12/25, steps were taken on 25/11/2025. And neither the ID card has returned nor the envelope written answer.
Heard Mr. N. Sharma, learned counsel for the petitioner. On perusal of the office note dated 15/12/2025, it appears that the notice issued to respondent, sole respondent, has not yet returned. Stop. The registry is therefore directed to place the postal track consignment report of the notice issued to the respondent by way of speed post before this court on the next date fixed. Let this matter be.
This is a transfer application of a matrimonial matter, which is fixed on 8th of January, Your Lordship. On the last occasion, Your Lordship asked me the next date. Accordingly, date was fixed today, so that it can be disposed of today. But as none appeared, so I pray Your Lordship that the further proceeding.
No, but we don't know whether you are husband or wife.
I'm wife, Your Lordship.
Okay. Next date. Let this matter be listed on 6th of February. 6th of February. However, considering the fact that the next date of the FC civil case number 974/2025 is fixed before the Court of Learned Principal Judge Family Court number 1 Kamrup Metro on 6th of January.
8th of January.
8th of January. Till next date fixed by this court, the further proceeding of the aforesaid case shall remain stayed.
Lordship, we have filed Wakalatnama for the respondent. Lordship.
Today.
No, 2 days back. Lordship.
There is an IA also listed here, but we have not been served with the copies of the IA lordship.
That's for second lordship. I'll ensure that it will be served to them.
Okay. Heard Mr. G. Bordole. Records have arrived.
No, Lord.
Heard Mr. G. Bordole.
NJ my lord.
Sorry. Heard Mr. N.J. Doimani. Learned counsel for the appellant. Also heard Mr. S.K. Poddar. Appearing for all the respondents. It appears from the office note that the records of the trial court as well as first appellate court have not yet been received. Issue reminder for the same. List this matter after receipt of the records. In IA, why IA? For what purpose?
I was regarding the stay.
So for my information, decree has already been executed, lordship.
Executed. Then it has become infructuous.
Petition has already been delivered to us, lordship.
You find out
Yes, Lord.
on the next day we'll pass.
Copy has not been served even.
In I write the name of both these counsel. Learned counsel for the respondent / opposite party has submitted that he has not received the copy of the interlocutory application. He also submits that he has been informed that in the meanwhile, the impugned decree has already been executed. Stop. On this, learned counsel for the applicant submits that he may be granted some time to take necessary instruction in this regard. The prayer is allowed. You furnish the copy to
Yes,
him.
lordship, I'll do that.
List this matter after receipt of the records in the connected regular second appeal.
Obliged.
22.
Yes, ma'am.
Yes.
My lord, a notice to the opposite party completed. This is an application under section 5 of limitation of.
You are objecting.
So we have filed objection, lordship, 940 days delay is here, lordship. Our objection is there, lordship. The explanation is not proper, lordship, and incoherent. We have already taken steps. We have spent in depth.
This is a appeal by claimant. For
For enhancement, my lord.
why the delay?
A delay, my lord, the ground of delay is mentioned from the para number 223. My lord, as the appellant claimant is residing in a remote area and there is no any well-known persons that they can advise her that there is a possibility to file an appeal for enhancement. So, my lord, I see there also some medical patient. I have annexed the medical documents, which is enclosed as annexure B and C. So, my lord, there are some other grounds that, my lord, the mother of the appellant and the father of the appellant was also in ailment, and she has to look after the mother and father. And now, my lord, she is residing in her own parents' house, and she is not residing with the husband's parents' house. So, my lord, she has a one baby, one children, and she has to look after the her. And my lord, the appellant came to know about of the fact that there is a chance of filing appeal, which is came to know on 19/11/2024, my lord. So thereafter, the appellant had engaged present against and counsel.
How much compensation was granted?
My lord, a compensation was awarded.
8,90,500. 8,90,500.
On what ground you are seeking enhancement?
Since my lord, the trial court has taken only the 3,000 per month as a national income. Although there is an organic evidence and he was a tractor mechanic. and therefore, there was an exhibited one salary certificate, 15,000. So that was not considered, my lord. So as nowadays, my lord, 3,000 is very much less as a national income. Therefore, my lord, it is all an appeal to enhance, at least maybe taken as a skilled labor, as a 8,000 at least.
Yes, Mr. Sakia.
We have taken objection noted against that in paragraph 11, 12 of our affidavit also. Other grounds are also there in 11, 12, but let me go through those. He is about 30 years old, but it is said that he is suffering from old age ailment. And advocate was lordship engaged on in 19/11/24, but he had filed for certified copy on 22/10/2024. These are incoherent, lordship. Their explanation.
Heard Mr. B.R. Das, learned counsel for the applicant. Also heard Mr. A.J. Sakia, learned counsel for the respondent insurance company. This application under section 5 of the Limitation Act has been filed by the applicant. We'll pass orders in January. Let this matter be listed for delivery of orders on 9th of January.
My lord, on 8th January, my thesis is also fixed. I am coming for not looking for. So
8th January.
8th January.
On 8th January.
Yes.
Yes.
My lord, in item 23, the notice to the opposite party is completed as per office order dated 16/12/2025. My lord, there is a delay of 932 days. My lord, the cause of delay is mentioned in para number 7/24, 7/21, my lord. And my lord, the appellant was seriously medical patient, and I have annexed, my lord, at least 10.
It is your claim was dismissed or
No, my lord,
enhancement?
enhancement, my lord. Enhancement, my lord, the grounds of enhancement is that, my lord, the trial court has taken only the 3,000 per month income. Although he was an employee of a motor dealer in Arunachal Pradesh, Naharlagun. One document was exhibited.
How many years?
And he
delay?
was 29 years.
No, how delay of how many years?
My lord, it's about 2.5 years, about 3 years, my lord.
9 January. 8 January for
Yes.
order. Same one.
24.
May it pleases your lordship, we were directed to take fresh steps upon performer respondent number 2. Lordship, his name may be struck off from the petition, lordship, as he did not contest in the trial court also, lordship.
Okay. This trial court case is pending before the trial court.
So had proceeded ex parte against the performer dependent number.
Okay. Heard Miss B. Devi, What is your name?
B Devi.
B. Devi, learned counsel for the petitioner, who submits that for the petitioner was directed to take steps for issuance of notice upon respondent number 2. And accordingly, the petitioner took steps also on one occasion. However, the notice could not be served. Thereafter, he was again directed by order dated 21/11/2025 to take fresh steps. Stop. However, she submits that the respondent number 2 is not contesting the title suit number 39/21 before the trial court also, and the suit is proceeding against him. Hence, the notice to the pro forma respondent number 2 may be dispensed with in this case. The prayer is allowed. The notice to pro forma respondent, the prayer is allowed. Stop. List this matter for admission hearing after Bihu vacations. The interim order shall continue till next day.
Please, your lordship, on last, lordship notice was issued, lordship. And lordship, record was called for.
Whether appearance is complete,
Lordship, I am appearing for respondent number 1, 2, and 3, your lordship.
how many respondents are there?
Lordship, there are 6 respondents, lordship. 4, 5, and 6 are proper mala, my lord.
We will be filing our Vokalatnama.
Heard Mr. R.K. Talukdar, learned counsel for the petitioner. Also heard Mr.
KJ Saikya, your lordship.
A.J. Sakya, learned counsel for respondent number 1, 2, and 3. On perusal of order date, office note dated 15/12/2025, it appears that notice to respondent number 4 has returned without service, whereas AD card, whereas the AD card issued to respondent number, AD card from the respondent number 6 has returned back with the illegible signatures thereon. And the notice sent to respondent number 5 have not yet returned. It also appears that the scanned copy of the trial court records have been received. In view of above, you take fresh steps. In view of above, the petitioner is directed to take fresh steps for issuance of notice by speed post as well as by usual mode against respondent number 4, 5, and 6. List this matter after Bihu vacations.
Deeply. Right, with your lordship. My lord, in this matter, lordship has called for TCR when it is received, my lord. And on the last occasion, I argued, my lord, the next date fixed for prosecution witness cross, my lord. So I'm praying for today. I'll make my submission on interim, my lord, today. And service for the private awaited and LCR received, my lord. And admittedly, my lord, in this case, the present petitioners, is the defendant in this case, they make an application.
No, no. This case has been listed in
is-
orders column.
My lord,
Orders
my lord,
column.
in orders
For
column, my lord,
service has to complete before we.
my lord, on
Wait.
22nd, my lord, the fix of prosecution witness cross-examination, my lord, directly and substantially, it is the issue in the earlier suit and present suit, my lord, I can show you. If a lordship not satisfied, then lordship may fix it for after consideration on this prayer, my lord. Admittedly, my lord, the present title suit and the earlier title suit, the prayer is the absolutely same, my lord. Kindly, my lord, I may be allowed to satisfy lordship. If lordship not satisfied, then lordship may fix, consider my this prayer on
Not
appearance of the respondents, my lord.
Suppose after appearance of respondent,
Yes,
we come to a conclusion that the second suit is barred by res judicata.
sorry, my lord, I could not,
Your plea is that second suit is barred by res
my lord,
judicata.
not, my lords, the certain prayer he made is not all the titles suit, my lord.
What is your prayer before?
My instinct case, my lord, they have challenged by the schedule to that already decided by the trial court, appellate court. as a
So what
official
is your
high court.
prayer?
My here case is made, since my lord, they are saying that I don't have.
You
any-
simply answer my query.
Yes,
What
my
is your prayer
Here, my
before
lord,
the trial court, which
before the-
was rejected by the impugn order?
Under section 11, we have made the application, my
So
lord.
that is what I am saying to you, that
Lord.
your suit is barred by res judicata. That is your plea before the trial court.
Absolutely, my lord.
So why are you beating about the bushes? You directly answer the query posed by. So suppose your prayer is in this civil division
My lord,
IO, we hold that the suit is barred by res judicata,
my lord.
then it will be stayed at any stage.
But the problem is, my lord, the situation is, my lord, on 22nd fixed for prosecution witness for cross-examination. How would it, since the already trial court had, on this point had rejected our prayer so far as regarding the earlier.
No,
pleas concerned,
that
my lord.
has to be examined by this court. Whether the trial court rejected your plea, that the suit is not barred by res
Yes, my
judicata.
lord, we have already. I
So
have-
we only propose to hear the other side before we pass any order.
my lord, that is absolutely correct, but since, my lord, all the records required for the consideration of my prayer, LCL is also available, it is also dear, my lord.
But other side is not available before us.
Since, my lord, then, my lord, the trial court proceeding is going on, prosecution witness evidence cross-examination fixed on 22nd of this month, my lord. If the cross, how could it make, so far as regarding the earlier suit is concerned, my lord, second, res judicata question is involved here, my lord. How could you raise this question raised to take plea on this case, my lord? So, my lord, some protection, maybe the further proceeding of the case may be stayed till returnable date, let them come, my lord, then lordship is satisfied, then lordship will find absolute order. That is my humble prayer, my lord. Otherwise, my whole prayer, already my case has already been decided by the trial court as well as the honorable court, this honorable court. They have not challenged this order before the apex court, my lord. So again, on same ground, they have filed a title suit, my lord. A lot of trial court held that parties are different, suit are different. Parties are same, my lord. The grievance is also same, my lord. At least some protection, my lord. Otherwise, we'll let them come, my lord. Till returnable date, I'm praying, my lord.
No.
Otherwise, the court will go for.
What will happen otherwise?
Otherwise, my lord, since the lordship can, my lord,
Nothing-
imperial order can be paid, my lord.
Nothing will, no substantial damage will be done by you. You face the cross-examination.
My lord, cross-examination for project, I'm to defend that, my lord. Cross-examination fixed for the prosecution witness, my lord.
You cross him.
Then it is bar already the trial court has rejected that plea regarding the res judicata question, my lord.
That we will decide in this case.
Some observation that, my lord, some observation, my lord, that so that we can go forward for project instead of obtaining interim stay, my lord, so we can raise the plea of res judicata before the cross-examination. Some observation, my lord. If the lordship pass this order.
Where
then-
is the impugn order?
Yes, my lord, at page 48. 21/12/2023, my lord.
What observation you want?
Yes, my lord. Since 22nd February, sorry, the December fixed for cross-examination of the prosecution witness, my lord. My only humble submission before this court, my lord, that since prosecution witness evidence cross is fiction, we may be allowed to raise the in the cross regarding res judicata question, my lord. That much observation, my lord. Otherwise, will be handicapped, my lord. We cannot raise any question of res judicata, my lord.
Why?
Since my lord stayed by the, rejected our that plea, my lord. So I am praying for till returnable death. Let them, appearance and lordship will dispose of the entire matter
No
on merit.
stay. Heard Mr. P.K. Dekar, learned counsel for the petitioner. On perusal of the office note dated 16/12/2025, it appears that the notice issued to sole respondent,
Yes, my lord.
sole respondent has not yet returned. The registry is directed to place the postal track consignment report of the notice issued to respondent, sole respondent by speed post on the next date fixed. The learned counsel for the petitioner vehemently argued for stay of the further proceeding of title suit number 7/2020 till next returnable date. Considering the nature of this case and contentions raised by the petitioner in his petition, this court is not inclined to grant any interim stay without hearing the other side. Hence, prayer for ex parte interim relief is rejected at this stage. However, learned counsel for the petitioner submits that the next date of title suit number 7/2020 is fixed on 22nd December before the trial court, where the plaintiff's witnesses are to be cross-examined by the present petitioner. He seeks leave of this court to raise questions regarding the bar of res judicata upon title suit number 7/2020 to the plaintiff's witnesses. Stop. Considering the fact that the issue of res judicata is to be decided by this court, the petitioner is allowed to put question. The trial court shall not restrain the learned counsel for the petitioner to put any question relating to res judicata regarding bar of the relating to bar of the res judicata upon continuation of title suit number 77/2020 to the plaintiff's witnesses. Let this matter be listed on 2nd of February.
May it please your lordship, I'm appearing on behalf of my senior. We haven't received any engagement letter or any document pertaining to the case yet. Yes, yes. We haven't received any engagement letter or any documents pertaining to the case.
Then why are you appearing?
Your name have appeared as legal aid counsel.
Yes, for respondent
in
number
the
1.
first list.
Item number?
27.
As legal aid counsel, you have been appointed as, why it has been shown as legal aid counsel? You are not engaged as legal aid counsel.
Yes, yes. He has been appointed as the legal aid counsel for the
No,
respondent.
but
number
in
1.
this case, In this case, whether any engagement has been made.
Just didn't yet receive any engagement letter or anything as such. For respondent number one, my senior is the legal aid counsel.
In this case,
Sir.
They have shown it as respondent one, but here in this case, there is only one respondent.
no, who has appointed you legal aid counsel? Where is the engagement letter?
Sir, my senior has didn't yet receive any engagement letter.
Then on what basis you are saying that you have been appointed as legal aid counsel? Third, Mr. MK Chaudhary, you have taken steps otherwise. MK Chaudhary, learned counsel for the petitioner. Also, Miss, what is your name?
FB Chaudhary.
S.
FB Chaudhary.
FB Chaudhary, appearing for Mr. K.M. Haloi, who submits that though the name of Mr. K.M. Haloi has been shown as legal aid counsel for respondent number one, however, Mr. Haloi has not received any order pertaining to his engagement as legal aid counsel for respondent number one. Stop. It appears from office note that notice issued by speed post to the respondent has not yet returned. The registry to take steps, registry to place the postal track consignment report of the notices sent to respondent by speed post before this court on the next date fixed. It shall also verify as to on what basis name of Mr. K.M. Haloi has been reflected in the cause list as legal aid counsel for respondent number one, and put up an appropriate office note to that effect on the next date fixed. Let this matter be listed on 2nd of February. The interim order shall continue till next date.
This case, our primary ground was that we did not get notice in the TS, and neither did we appear. But somebody appeared on our behalf with a forced signature. So the trial court record may be required so far as ascertaining the signature is concerned. And also file WS on our behalf with a forced signature.
Forced signature.
I mean, we have seen the signature in the Xerox copy of the WS. It is not our signature.
And the suit proceeded ex parte against you.
Yes, later on proceeded expert. After the WS, no one stepped in.
Thereafter, you prayed for setting, have you prayed for setting aside during execution stage? Now, in this CRPI, what relief you are seeking? Okay, we'll see later on. Let the scan copy of the
The TS case is TS 22 of 2017 of Civil Judge Junior Division number 2, Dorong Mongalore.
no, let the records of title suit number 22/2017 be called for from the Court of Learned Civil Judge Junior Division number 2, Dorong Mongalore. Registry to take steps for requisitioning the record. List this matter accordingly on 2nd February.
for the office note dated 15/12/25. You can see PCR was called for but not received yet, as well as the service for respondent number 2 and 3 was also not served, unserved return. So, since the youngest counsel of the respondent number 1 and 2 are appearing in the trial of the owner, so kindly I may be allowed to take a step for through the youngest counsel.
Under what provision? You show me the provision, I will allow it. There is a provision.
As per the last address, we have taken a step for the respondent of 1 and 2,
But it has returned without service.
yes. Since they are appearing through their youngest counsel in the trial.
You show me the provision in CPC. Go through CPC, point out the provision, and allow you your prayer. Come prepared. Heard Mr. Esnas. What is the name?
AI.
Hi. Learned counsel for the petitioner. Also, on perusal of the office note dated 15/12/2025, it appears that the notice is issued to respondent number 1 and 2 has returned with postal endorsement within bracket address, within inverted comma addressee left RTS. Whereas notices issued through usual mode has not returned back. Wait for the service report in respect of service report of the notices sent through usual mode. It also appears that the scanned copy of the trial court record have not yet been received. Let the reminder be issued for scanned copy of the trial court records. Let this matter be listed on 7th of January. On 7th January, you show me the provision.
Next date is fixed by the trial court 6.
Okay, 6th of January.
Item 30.
Lordship, in this matter, we have filed an IA to withdraw our names from the present case, Lordship.
Two,
To withdraw our names from the present case, Lordship.
names of the council.
Yes, Lordship.
Why?
Lordship, matter first came upon Lordship 15/7/2016. And since the filing, Lordship, the petitioner has no contact with us.
You have informed the petitioner through
Lordship, 5/6/2025, we had sent a register letter, Lordship. Your Lordship may kindly see it in page number 8, Lordship, Annex A1.
Yes, Mr. Bhagawati.
Lordship,
Do you have anything to say?
only thing I am also representing that person. my name has been shown in the cause list, so therefore I have to come. Respondent number 5, Onima Dasil, since long she died. Even I heard that the petitioner promised that she also expired. So therefore, the matter has already become infectious. আমাকে খবর দিছেন আমাকে খবর দিছেন কিন্তু মই ঠিক শিওর না তো মোর মনে কোনে খবর দিই
Okay. Heard. Mr. What is your name? R. Gohai, Learned Counsel for the applicant. Also heard. Mr. B. K. Bhagavati, Learned Counsel for the respondent.
Respondent number 5.
Respondent number 5. This application under Order 3, Rule 4 of the Code of Civil Procedure has been filed by the petitioner, by the counsel of the petitioners, praying for allowing them. How many counsels are there? One. Allowing them to withdraw the Wakalatnama from the instant civil division petition. Learned Counsel or the petitioner has submitted that Learned, no, this application is by counsel himself.
Yes, Lord.
Learned Counsel for the applicant has submitted that the applicants Laban Bhardwaj, Teen Srinivasan, and A. Barkotaki were engaged by the petitioner of in connection with CRP 224/2016. However, since when this petition is filed by counsels or the petitioner?
At least this notice may be issued to the person on the court side because it is not known, as per my knowledge goes, that he is the person, he is a dead man.
The counsels are not in contact with the petitioner of CRP, case number 224/16, since the year 2016. And should we issue notice?
It will be better.
Okay. Stop, 2016. Issue notice to the petitioner of CRP case number 224/2016. No, but
Since they have decided to withdraw their Wakalatnama.
the present applicants shall take steps for issuance of notice by speed post within 7 days from the date of this order, returnable on 3rd of January, 3rd of February. List this matter accordingly.
My name may be dropped because I am representing that person now. Respondent number 5.
No, let it remain till next day. On next day, we will find. Eta submission ಇದು Mr. B.K. Bhagavati has learned counsel for respondent number 5 has further submitted that in the meanwhile, respondent number 5 has also expired. And therefore he prays for prays for not reflecting his name against as an engaged counsel for respondent number 5. The prayer is allowed.
Wait, please, your lordship. Lord, may kindly take up the I 4120, my lord. In fixed deposit was directed in MSC appeal, my lord. We are trying to bring for disbursement of that fixed deposit.
Your
But
Honor,
for
we have not received a copy of the IA, Your Honor.
nothing, we can give him only for disbursement is there.
You have any objection?
Judgment, Your Honor, for directed.
Okay, you give
6 lakh rupees were
We
directed
have
to
to
the
take the instruction from the insurance company, Your Honor.
the insurance company has no role to play here, my lord. It is between the court and the claimant, my lord. Again, for this matter, it will again come up with a.
no. You furnish a copy to the will.
That-
Heard Mr. A. Learned counsel for the applicant. This application has been filed by the applicant claimant praying for allowing the applicant to withdraw a sum of rupees 6 lakhs. No, why this prayer has not been made by before the tribunal?
That point of time, I was not needing the money. The claimant was not needing the money. 1 year has passed by now, he needs the money. That is why this prayer has been made to him. He's got some infection actually in the leg, my lord. He needs to get operated again. There was amputation of the leg, so there was some urgency in the matter, if you lordship can consider.
Who has filed the appeal?
We have filed the appeal for.
For enhancement.
For enhancement, that is pending.
Then you may not have any role in this because this is for release of the, still we will fix one date. 6 lakhs, which was deposited by the claimant as fixed deposit in pursuant to the directions given by the Motor Accident Claims Tribunal in the impugned judgment, which has been challenged by the present applicant in the connected MAC appeal number 505/2024. Learned Miss, what is your name? Miss N. Talukdar, learned counsel for the insurance. Opposite, respondent number 1, opposite party has submitted that this insurance company has not received any copy of the instant interlocutory application. Hence, prays for a copy of the same. The learned counsel for the applicant shall furnish a copy of the interlocutory application during the course of the day. This may,
7th or 8th, my lord.
let this matter be listed again on 8th of January.
And
Yes, Mr. Chakravarti.
Lordship. Lordship, the affidavit was already in the file.
It was there.
It was there. Ase na?
IA to দিয়ক। Yes, the applicant who is the official liquidator is
Mr.
praying for
Yes, sir.
Liquidation of the lordship.
Not the liquidation, Your Lords. I am just asking that the assets of the cooperative be sold as a be sold as a NRRA with all the litigation and everything. So basically, the purchaser will now, buyer will step into the shoes of the liquidator and continue these proceedings, Your Lords.
Yes, lordship, it seems to be simple, but not that at all, lordship. It's a question of right title interest, lordship is involved. Ownership of the land is involved, lordship. Now, lordship, when they come to page 12, they have already stated that they once tried, but they failed. Twice they failed, once they have withdrawn. Now, lordship, this
page number
page 12, lordship, paragraph I.
of IA.
IA, page 12, paragraph I. They themselves admit due to the pendency of the suit, they could not.
Your Lords, but thereafter it was
Let
sold
me
out.
finish. I did not disturb you while you were submitting.
Yes,
Lordship, paragraph I.
paragraph.
I.
Yes.
Married during the liquidation of Messrs.
Now, what you want to say?
They themselves admit due to the pendency suit, they did not went for it. Once they later then they have also stated that they have withdrawn. Now, lordship, this implement of the liquidator was allowed way back in 3/1/23 in the suit. He himself adduced as a defense witness. He himself adduced evidence. Now, at no point of time they took that plea that they want to go for a selling of the assets. And lordship, by virtue of
No, now they are saying that
yes, let the
National Company Law.
Yes, they themselves, lordship, after the account was declared NPA, thereafter they advanced 3.9 crore. Now they want to pass their the fault to us, lordship. Why did they advance loan after the account was turned to be a NPA? That will lordship will find page 23, paragraph 8. The town loan account number so-and-so was classified as NPA on 26/2017. That on request made by the corporate debtor and on recommendation of the journal office of the financial creditor, the credit facility was renewed by this sanction later dated 21/10/2017 by sanctioning 390 lakhs. That is 3.9 crore against their advance. Why did they did so?
Your Lords, may I clarify?
No, I have yet to finish.
Okay.
Now, lordship, if you take our reply,
Like,
lordship, we come to page 89.
yes. Yes,
Page 89, lordship.
yes, it
Our
is a,
reply. That is the Chitta copy, lordship. On the remarks column, lordship. I'm referring to the, I have furnished the translated copy as well. I'm referring to the vernacular one. Kheraz Beti 508 number pottat likha, hukum mote ei pottar, so and so dagor komudai jomi NF railway namot sorkari koron kori nothi, honkhodon kora hol. So the land was in our name. It was recorded in the Chitta as well. all this has been not considered by the land trial court below. The land as on date is stood in our name, Lordship. Even Lordship, I have a report of the circle officer. Hey,
No, but they are not praying for
if the
selling
land-
of land.
If the land is, if that flat is sold, Lordship, to third party right will be created. Someone else will. it will-
But that would be subject to all litigations and encumbrance.
Lordship, it will create more trouble,
Eh.
Lordship. Let the whole appeal may be heard at the earliest. I'm ready to immediately after revocation.
No, your case is
The land
The-
belongs to us.
on the basis of the endorsement in the chitta.
Not only that. Lordship, this is the that acquisition, that notification have enhanced, Lordship. In my reply. Lordship will find it. The serial number 5. The dark 545 has involved, Lordship. The compensation amount like that has been paid. It's this maintained by the Deputy Commissioner Office, Lordship, this one.
Paid to whom?
Paid to Lordship,
This land was acquired by Union government.
Union of India.
Then, and the compensation paid to,
All the
including the,
present land in India. And that is why our name has been registered, mutated in our name.
in your objection, you have taken that plea. In your written objection, have you taken that plea?
To this petition?
Yes.
Yes, Lordship.
Where? Where is the statement? Page number?
Paragraph 4, Lordship. Page 82.
Yes, please read.
That with regard to the state made in paragraph 3 of the application, the answering OP begs to state that and reiterate that as the instant application being not maintained with such, the question of seeking permission to sell the assets, including moving the suit land is issued affirming is also therefore not maintained. It is further stated that the suit land belongs to the railway, and thus if the suit property or any part of it, including the building standing over the suit property is put on sale, a third party right will be placed in the same will cause resulting multiplicity of litigation, such the instant application is liable to. The fact that the suit land stand in the favor of railway is evident from the chitta copy obtained in this regard, wherein it has been clearly stated that the suit dug land in recorded in favor of the railway. The award list is also clearly shown the acquisition of the present dug number 208 new, which is emanated from the old dug number 545/50. In fact, the adjacent land is in respect of another dug number so and so has been decreed. The adjacent land has been decreed in our favor, Lordship.
No, that is a different aspect. But the present land,
Lordship. This paragraph deals with the DUG 208, Lordship. That is which is earlier 545. that stood in our name. And that amount has been paid, that has been dealt with paragraph number 11.
Your Lords, may I submit?
I'll come to you.
Please, Lords.
Now, the question is that when the who is the decree holder?
But we filed the suit. Our suit was dismissed,
Oh, yes.
claiming right title interest. We filed two suits. The adjacent suit has decreed in our favor, but this was not.
And against that, you have to
Against
prefer
that, we
the
have
present.
approached this. So if lordship is now, if your lordship allows to sell the flat lordship, the property, it will give rise to multiplicity of suit lordship.
Your claim is over land only.
And it's our land.
And they are not paying for selling of land.
So selling the, because the building has been constructed over the land.
Yes, anything else?
That's not.
Yes, Mr. Goenka.
Yes, Your Lords. Your Lords, they have not replied to the query which the bench asked them last, no, the last date of hearing. Like, what is the difficulty if a person instead of me comes into the picture, Your Lords? Their
Yes.
main contention in this is that third party rights will be created. I am just saying, let me go out, let me close the liquidation. And the other person who will step into my shoes will take all these contentions before Your Lords. There is no multiplicity of litigation, Your Lords. Your Lords, as per the IBC code and as per liquidation regulation, a liquidation has to be closed within 1 year. And then extensions can be sought, Your Lords. But this litigation has been going on for, I think, more than 5 years now, before the trial court. And before this court, Your Lords, it's been pending since 24, Your Lords. There is very unlikely that the matter will be taken up. And because of this, the entire liquidation is put on hold. I am just saying that let me sell as it is, as is where is based with all the litigation and everything. I am not asking for any other relief other than that. And anyways, this will be taken care of by the NCLT. I will anyways have to approach NCLT, bring to their knowledge about all these contentions that I want to sell it. Earlier, I had a buyer. It is not that I did not have a buyer earlier. Because he defaulted in the payments, subsequent payments, I could not sell. I am just saying that let me go out, someone else will. It's like assigning a debt, Your Lords, which banks usually always does. Or a party can, like tomorrow, today, if I have a decree in my favor, I can assign that decree in favor of someone else also, Your Lords. That person will now step into my shoes and then continue the litigation if there is any appeal. I am just asking for that parity, that's Your Lords. Because ultimately, if the bank has ultimately the SEC, the committee of the stakeholders committee is the banks and the operational cadres, Your Lords. They will not be able to fund this litigation, Your Lords. I am just saying that the person who will come, he will fund the litigation, he will do whatever he wants with this litigation, and he will suffer the consequences. Either he wins or loses, Your Lords.
No, whether in these interlocutory applications,
yes, Your Lords,
other respondents have appeared.
Your Lords, there was the other have not appeared, Your Lords. There are not others. As per the memo of appeal, Your Lords, the other respondents are the suspended directors and Your Lords, the people who were actually the owners of the land. I am a corporate debtor. I'm a company who has a development right on that land.
No,
Yes,
that
Your
is, you may have a point.
Yes, Your
But
Lords.
whether they are also required to be heard.
No, Your Lords, if
Only.
Your Lords, even if the NCLT order, if Your Lords, I have filed that application for selling it as an NRRA before NCLT also. NCLT had allowed it but as not allowed it.
This
Yes.
court directed you to take steps.
Yes, Your Lords.
for issuance of notice on other respondents, 2 to 7.
Perhaps
Yes,
that
Lord.
was not done, Lordship. Subject to correction, Lordship, what is reflected in the office.
Your Lords, my
note.
local counsel will be able to inform on that. As per
Yes,
my
Mr.
information,
What is your name?
Arup, sir. AR Pal.
AR? Mr. Pal. There is no Okay, okay.
we can strike them off also, Your Lords, because they are not required to be heard in this application, Your Lords.
Who are 2 and 3?
2 and 3, Your Lords. Rita Mandal and Your Lords,
The corporate data, Lordship.
The corporate debtor
yes, Your Lords. In my IA Lords or in the main RFA Lords?
in IA.
In IA Lords. 2 is Rita Mandal, Your Lords. She is the owner of the land. Indian Bank is the, Your Lords, the creditor who had advanced loan to the corporate debtor,
No,
Your Lords.
at least notice have to be served on the owner of the land as well as the corporate debtor.
The corporate debtor, sir, Your Lords, I am the corporate debtor. I am liquidator, I am representing the corporate debtor. That's the difficulty, Your Lords. They filed this RFA without making me a party as a liquidator, because once
No,
a companies
but
goes in,
as they have been shown, the Messrs. Guwahati Construction Private Limited
yes, Your Lords.
is in existence. You are looking after affairs of
Guwahati Construction Private Limited, Your Lords. I am the liquidator. I represent this is the corporate debtor. I represent the corporate debtor.
then notice has to go to respondent number 3.
Your Lords, as per the
And
information,
direction was there.
yes, Your Lords, as per information given to me, steps were taken on 2nd September 2025, Your Lords.
Yes, but notice has returned with a report that no such address in the address. We have to ensure at least the service of notice upon respondent number 2. Even if we agree with your submission that number 3, the corporate debtor is represented by you,
Yes, Your Lords.
but to owner notice has to go.
Your Lords, but then that there is very unlikely chance that they will appear because there are other
No,
proceedings.
even if they don't appear, we
Yes,
can
Lords.
proceed against them ex parte.
Your Lords, but I am only concerned about the development rights. I am not asking to sell the land, Your Lords. As explained in detail, Your Lords, NRRA I can sell, which is not readily available to me right now. This is an asset of the corporate debtor, Your Lords. This will prolong the liquidation and put a burden on the Indian bank and other creditors of the corporate debtor, Your Lords. More.
Where is the prayer of your interlocutory application?
Please, Your Lords. Page number 15, Your Lords. Of my IA. Page 15. Your Lords has it?
Yes.
Yes, Your Lords. Your Lords, the last lines. Permitting the applicant to assign the assets of Guwahati Construction as non-readily realizable assets as is where is basis with all the litigation and encumbrances on the said asset.
Okay.
And this is only in the interest of closing the liquidation, Your Lords. That's it. Otherwise, the liquidation will keep on going on, and it is affecting the liquidator's
Now, how
performance.
will you overcome the issue of notice to respondent number 3? What is your submission?
Your Lord's respondent number 3, as far as this, I am not concerned about her property. I am just telling that she had already given me that right to construct on that property. And that has been upheld by NCLT, considered by NCLT also, and the lower court, and all these were before the lower court. It is not that the lower court was not aware of these proceedings and this development. It has taken a holistic view and then has dismissed the suit filed by the union, Your Lords. And because of the blanket stay order, that is why I am just appearing before Lords, because otherwise, if I would have sold it in NCLT, I might have invited a contempt order, Your Lords. That is why I am coming to you and seeking a prayer. Otherwise, my jurisdiction was with NCLT. I am coming here because otherwise, if interpretation of law would have been considered, then they would have filed a contempt against me that why did you sell the land when there was a stay? Technically, they could not have filed this.
No, you are not going to sell the land.
No, not the land, only development rights also, Your Lords, because it is on the status quo on the property, Your Lords. That is why, Your Lords. There's a blanket stay in their favor. Otherwise, I would have approached, if there was only on that particular issue, that on the impugned order, if there was a stay, I had no issues. But this is on the property. That is why, Your Lords, I had to approach you. Otherwise, I would have gone to NCLT, sold my development rights and closed the liquidation and everything, Your Lords.
So notice to respondent number 3, what is the submission?
Your Lords, Indian Bank?
No, respondent number 2.
Sorry, Your Lords, Rita Mandal was the wife, if I'm not wrong, Your Lords.
No.
Is the owner and
What is your submission? How to deal with this issue?
Your Lords, she's not. Acha, Your Lords. Your Lords, she's not required to be. She's not an interested party in this. As far as me, as a corporate, as a liquidator, selling the development rights of the land is considered. Your Lords.
What is your prayer?
Your Lords, my prayer were not. There's no prayer against respondent number 2.
No,
Your Lords.
as regards notice to respondent number 2, how should we deal with it?
Your Lords, I'll request that she be striked off from the array of party, Your Lords. I'm just requesting that. Otherwise, Your Lords, because otherwise, Your Lords, the other option available to me is that I will immediately take steps again for issuance of notice, because this was not.
You take fresh steps.
Please, Your Lords, I will do that.
Heard Mr. N. Goenka, learned counsel for the applicant. Also heard Mr. B. Chakravarti, learned central government counsel appearing for opposite party number 1. On perusal of the office note dated 16/10/2025, it appears that the notices issued to respondent number 4, 5, and 7 have been duly served on the said respondent, and therefore these said notices are held to be duly served. Stop. As regards respondent number 2 and 3 are concerned, same have returned without service. Learned counsel for the applicant has submitted that since the applicant is the official liquidator of respondent number 2, and it is he who is representing respondent number 2, the notice to respondent number 2 may be waived. Is it your submission?
Yes, Your Lords. Yes, Lords.
May be waived.
I'm not seeking any prayer against her anyways, Lordship.
Yes, you are representing respondent number 2. Respondent number 2, the corporate debtor,
Yes, your Lordship. Yes, your Lordship.
the prayer is allowed since the present applicant is the official liquidator of the respondent number 2, Messrs. Guwahati Constructions Private Limited. The notice of this interlocutory application to respondent number 2 is waived. However, as regards respondent number 3 is concerned, who is the owner of the land of which owner of the land, owner of the suit land, over which the assets of corporate debtor stands and the prayer for assignment of those assets in favor of the present applicant has been made in this case. This court is of considered opinion that service of notice upon the said respondent is necessary. Hence, the applicant is directed to take fresh steps for issuance of notice upon the respondent number 3, Srimati Rita Mandal, by speed post as well as by usual mode within 7 days from the date of this order, returnable on January 13th. Before that, returnable on 19th January. Release this matter accordingly.
Please,
19th January. Connected RFA, similar order book. Only regarding issuance of notice to respondent number 3. Yes.
Need to resolve this RSA, my lord,
Item number?
for the supplementary list. But this RSA, my lord, was admitted on 8/10/2025, my lord. And my lord, we had to take steps upon the respondents, my lord, we took the steps, my lord.
What has happened to that?
So, my lord, it will, my lord,
We'll ask the postal track concern.
yes, my lord, this may be, my lord, fixed returnable date, my lord. And regarding, my lord, there's an IA also, my lord, connected IA. IA is for, my lord, the stay. So stay was also granted, my lord.
Okay.
So the thing is that, my lord, the matter was fixed on 17/11, both the RSA and the connected IA. On 17/11, my lord, the matter was left over. So, my lord, the protection, my lord, has to be extended, my lord, till the returnable date, my lord, in the IA.
I so heard Mr. S. Das, learned counsel for the appellant. On perusal of the office note dated 6/12/2025, it appears that the notices issued to respondent number 1 to 20 by speed post have not yet returned. The registry is directed to place the postal track consignment report of the notices issued to respondent number 1 to 20 by speed post before this court on the next date fixed. Let this matter be listed on 2nd of February. In IA also same order. IA also same order. Last line likhebo. The interim order of stay of execution in the title execution case number 1/2023 as granted by order dated 8/10/2025 shall continue till next slide.
Highly obliged.
Please, your lordship, an IA has been filed in regards to order dated 7/11/2025. The case has been mentioned admittedly incorrect as 18/2014. It should be 18/2024 in paragraph
Where?
number 2.
Where in para?
Sorry, sir.
Where is the impugn? Where is the order where?
Annexure 1.
Page number? In which para wrongly mentioned?
In para number 2 and 10.
It should have been 18/2024.
Lordship.
Heard, Mr. What is your name?
S. Chaudhary.
S. Chaudhary, learned counsel for the applicant. This interlocutory application has been filed by the applicants praying for correction of the typographical error which has crept in the order dated 7/11/2024 passed in connection with criminal petition number 1338/2024. Learned counsel for the petition
38/2025.
2025, sorry. Learned counsel for the petitioner has submitted that in paragraph number 2 as well as paragraph number 10 of the aforesaid order, the year of the special POCSO case number has been mentioned as 2014 instead of 2024, and same is required to be rectified. Stop. I have considered the submissions made by learned counsel for the petitioner and have gone through the records. It appears that in paragraph number 2 and paragraph number 10 of the aforesaid order, the special POCSO case number has been mentioned as 18/2014 instead of special POCSO case number 18/2024. This appears to be due to inadvertent typographical error, which is required to be rectified. Stop. Accordingly, this interlocutory application is allowed. The special POCSO case number mentioned as 18/2014 in paragraph number 2 and 10 of the order dated 7/11/2025 in criminal petition number 1338/2025 shall be read as within inverted comma special POCSO case number 18/2024. This interlocutory application is accordingly disposed of.
42.
May I please, your lordship, the IA for the condemning of the delay of 8 days.
Heard, Mr.
And
N. Ahmed, learned counsel for the applicant. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of February.
If the obliged.
In this matter, in MSc appeal number, it's a filing number. The name of Mr. Siddhant Datta is wrongly shown in the cause list.
Item number,
Item number 42, Your Lordship. In Siddhant Datta,
item, what is your name?
S. Pal.
Also add Miss S. Pal, learned counsel, who submits that in the cause list against the appeal filed in connection with this case, name of Mr. Siddhant Datta has been wrongly reflected in the cause list. Stop. Accordingly, she prays for appropriate direction to the registry. Stop. Registry is directed to not to reflect the name of Mr. Siddhant Datta as an engaged counsel in against the connected MSc case in the cause list henceforth.
46.
Wait. I have verified the judgment and found that there is two part in the Surya Devrai case. One part is regarding maintainability of a certiorari under a order of civil court, and the other was supervisory jurisdiction. That maintainability of certiorari was overruled, but the other part is there also. It is accepted. This court upheld the order of the Surya Devrai on that point.
Okay.
So.
So
it is
this,
maintainable.
it is maintainable.
Yes, sir.
Okay.
Lordship, my second, there is a prayer. I have filed a petition under order 7 rule 11B. Because the suit is, as per the records, is not maintained time barred. So that is fixed on, for order on 6th of January. So this matter may be taken up after that course. And one more thing is there. Lordship, in the petition, my learned friend has most probably inadvertently failed to annex one document of the defender, which is very relevant in this case. So he may annex that document in the case also.
Firstly, Lordship, I will satisfy that part, Lordship. He raised by filing an application under 7 rule 11 on limitation point. Lordship knows very well that limitation is a mixed question of law and facts, but that cannot raise at this stage, Lordship. And in connection with this appeal, Lordship, that part will not come definitely.
The CRPIO is for, here you are challenging the appellate's court order,
Lordship,
rejecting
setting aside my injunction order passed by the learned trial court.
And the injunction was to the extent not to alienate the suit property.
Lordship, here, not to use the banner of petitioner number 1 union by the defendant number 1 and 2 as president and secretary. The matter is otherwise very urgent, Lordship. Unnecessarily, my learned friend raised a question on maintainability issue after, while matter is fixed on 5th time. And here, the order 39, here heading is there, Lordship, temporary injunction and interlocutory orders. So, unnecessary delaying my matter.
Lordship may see.
This part may be
288.
heard. And regarding
Page number 288 of the
non-annexing of document, I have certified copy of entire memo of appeal and annexure. So that may consider, Lordship. Certified copy, Lordship.
Okay, what is your
So come
submission?
to page number 288.
Now let him submit his case.
Because what I am saying that the one document is not annexed.
That
Yes.
may consider, Lordship. I have certified copy.
Page number?
Page number 288, paragraph 31. The opposite party number 1 and 2, basically said that according to the terminals in the second paragraph section 3, 2024 under return officer SPE3 and PCPO. NFL Malaya is going to be held on 4, 5 and 6 December 2024, and in the said election, the opposite party union, namely Burgotra Cemento Railway Conversation.
Which para you are reading?
para 31, Lordship, page number 288.
That is,
Here, Lordship, they have the opposite parties, that is the respondent hearing. They have annexed the list of contesting railway trade unions for secret ballot election 3/24. That was in our name. That document is very much relevant for consideration of this case. But while filing this petition, that document was not annexed by the petitioner.
Considering this submission, Lordship, my part may be heard if necessary. Otherwise, I have certified copy, Lordship.
Here is a question of
entire-
granting order, Lordship, granting a
If
stay,
such
and I
necessary.
want to file my objection.
Right. They are delaying the matter intentionally, Lordship. If I am not mistaken, today is 7th day, 6th or 7th day.
No, why
He
why
is
have you
appearing
not?
here as caveator from the date of first listing.
But they have not annexed one important document, and without that, that was our document. It was annexed with our objection, Lordship.
My part may be heard, Lordship. If such necessary will arise, definitely Lordship will consider.
Yes, what is the submission?
Lordship, the present petitioner as plaintiff preferred this suit, preferred title suit number 633 of 24, seeking a decree of declaration, certain declaration, permanent
Six,
injunction.
six,
633 of 2024.
yes.
Lordship will find the plan at page 15. Here, Purvottar
You
Simha,
have not filed any written objection.
Lordship, no notice of motion has been issued till now. Lordship. This case.
was appearing as caveator, caveator deterred.
Let them file. a
Not
written-
necessary, Lordship. I have annexed all these documents, including the memo of appeal. Otherwise, also I have certified copy of entire appeal record.
No, but they may file objection against your.
Also, matter is otherwise very urgent, Lordship. Today is
So
7th
it
day.
was filed in the month of June. Today is December, and I am praying that it may be delayed till 6th of January. On
I
that day,
will
order will come.
satisfy that part.
So
Lordship.
these 15
Definitely
days
I
shall
will
not make any
satisfy that
difference.
part. Unnecessary delaying this case.
I mean, I have the right to file my objection also in this case. I may be allowed to file the objection.
Otherwise,
in the meantime.
227 is
And they are-
concerned, Lordship has.
They are not
considered
annexing a
what
document. Now they are
illegality-
not accepting this
Cannot-
list of
One
No,
of
we
the-
will hold that this regarding maintainability issue, we will decide that and give him a chance to file written objection on the reopening day.
Taking advantage of that appellate order, Lordship, they are continuously doing various illegal acts. Including, Lordship, last a notice was issued, Lordship, kindly peruse this, the act of the respondent side. Even the person.
What is this?
Taking advantage of setting aside that order, they are using continuously the name of present petitioner number 1 union in various fields and claiming themselves as president and secretary. Whereas, Lordship, they are retired person. As per constitution, Lordship,
No, what will happen in between 6 January to? In between today and 6 January? Is there any urgency? Heard Mr. R. Ali, learned counsel for the petitioner. Also heard
also.
Mr. R. Sharma, learned. He could citation will give this. A case of citation like this in a petitioner.
Notice, Lordship, one part may be considered. In fact, now railway is taking Lordship opportunity. Now this letter,
Railway is not a party here.
not party Lordship, Harish Bhuya, who is defendant number 2 in the main suit, issued this letter to general manager Lordship, saying that we are outsider. We are taking illegally the name of petitioner number 1 union. Whereas
Okay.
they did not file any counterclaim.
Okay.
And regarding my stand of their retirement, that is also admitted, Your Honor.
Oh, that we will
No.
consider.
Now they are taking some different view before appellate court for the first time.
Harshan. Though the learned counsel for the respondent had raised the plea of maintainability of an application under Article 227 of the Constitution of India, challenging the order of an appellate court passed under Order 43, Rule 1 within bracket R of the Code of Civil Procedure. However, he has now fairly considered that the case of Suryadev Rai versus Ramchandra Rai and others reported in 2003, 6 SCC 675 has laid to rest the said controversy, and he further submits that the
Last page, 1.28.
the apex court in the Radhesham, in the case of Radhesham versus Radhesham and another versus Sabinath and others, reported in 2009 5 SCC 616, has not disturbed the finding as regards maintainability of an application under Article 227 of Constitution of India, putting to challenge an order passed by the appellate court under Order 43, Rule 1 R of the Code of Civil Procedure 1908. In view of the fair submissions made by learned counsel for the respondent, as well as the submissions of learned counsel for the petitioner, the issue of maintainability of the instant civil revision under Article 227 of the Constitution of India is put to rest. It is hereby held that in view of the observations made by the apex court in the case of Suryadev Rai versus Ramchandra Rai, within bracket Supra, the what is barred is an application under section 115 of the CPC and not an application under section Article 227 of the Constitution of India. Stop.
In some subsequent judgments, it has been also found that 115 is also maintainable.
Okay, what is barred? A line to change for it. Production made by the apex court. no, what is word continue? An application under Article 227 of the Constitution of India is maintainable. Challenging the order of an appellate court passed in challenging the order of an appellate court passed under order 43 rule 1 within bracket R of the CPC is maintainable. Stop. Learned counsel for the petitioner respondent submits that since this court is yet to issue notice in this case, the respondent may be granted an opportunity of filing a written objection in this civil revision petition. On the other hand, learned counsel for the petitioner has objected to further adjournment in this case on the ground that the respondent has appeared in this case as a caveator on the first date itself in the month of June 2025. However, he has never paid for filing of any written objection. Rather, he had intentionally raised the issue of maintainability only with a view to delay the disposal of the present civil revision petition. He further submits that the respondents are illegally using the name of the petitioners association, taking advantage that the first appellate court has declined to grant any interim injunction as temporary injunction as sought for by the petitioner. He therefore submits that the matter is of urgent. Considering the urgency, the matter may be disposed of today itself. I have considered the submissions made by learned counsel for both sides. Though on perusal of the records, it appears that the respondent has appeared in this case when have you appeared?
By filing caveat also. On the
And
very first listing.
on the very first day of listing of this case. However, he has not filed any written objection yet. This court is of considered opinion that considering the facts and circumstances of this case in its entirety, one opportunity of filing written objection to the respondent may be granted. Accordingly, the respondent side is allowed to file written objection on the next date fixed. That is on when?
But the matter may be fixed on 8 or 9 January.
On 9th of January.
At least
And the respondent shall furnish the copy of written objection to the learned counsel for the learned counsel for the petitioner well in advance before filing the same in the court. Let this matter be listed again on 9th of January.
we can go to dispose of on that day.
We'll try.
Put here, item 42.
Lordship, in regard to the minor petition,
Today, this matter was fixed for,
Only I'll submit some decision, my lord. Very important is that, my lord, earlier case, my lord, first claim petition was rejected. It was very much clear in the judgment, dismissal judgment. The learned tribunal has decided 166 because he has failed to prove the ration negligence, because it is a case of 302. And also, the learned tribunal also come to the, to convert the case 163A, because here also failed to convert, because he has shown his income is 4,000. So it is beyond limitation of 40,000 per annum. So both the side dismiss. Now against the dismissal judgment, my lord, my friend has prepared an appeal. The appeal also, my lord, remand back with a direction to consider Rita Devi's case. But in this Rita Devi's case is a case of 163A. It is not a case of 166. So after remand back, after giving the decision, that is a impugned judgment herein, my lord, that this learned court also come to the finding, because the Rita Devi is not maintainable, because his case is 166. 166 has to prove the ration negligence. So there is a, my lord, provision to file either in the WC code or motor accident under section 167. So he preferred claim petition in the before the MACT code. So he has to prove 166. There is a no proof, there is a no document, there is nothing, because it is a murder case. This is a murder case, my lord. The second thing is that, so although he has paper, it is not a claim petition under section 163A. In this regard, our High Court and other courts also, that cannot be converted to 166 to 163A, because both the, my lord, provisions are independent. Number of judgment, my lord, I placed before today. And third thing is that calculation, lordship also put me the question on the last day. The calculation made by the learned tribunal on the basis of the WC code, that is the dependency, that cannot be, because Ponoshiti is the latest judgment. Earlier, as lordship knows, this number of cases in the Ponoshiti case also referred structure, the how to decide, how to calculate the dependency. So I am giving the Ponoshiti and also I'm giving the one statement, my lord, how to.
no, the tribunal was wrong in computing the
Yes, that is my case.
compensation on
Yes,
the
because-
basis of Employees Compensation Act. Section 4.
That cannot be. That cannot be, because both the MACT and WC.
That is admitted by the other side also.
Yes, his
You are,
judgment.
you are also admitting that the tribunal was wrong to that extent.
That his judgment.
You have admitted on last occasion.
Yes. That is why.
I
he
was
has a-
fairly admitted.
Yes, I am also saying that you have fairly. Okay.
My lord, in this regard, I'm giving the one, how to assess the compensation in death cases. I got it from.
My lord,
online.
I would like to highlight the fact before your lordship, I think.
I'll give you some time. Yes,
So I'll give this, my lord.
you have to only submit judgment. Submissions you have already made.
So this impugned judgment is not maintainable, it's liable to be set aside by this honorable court. Because wrong quotation, even then wrong quotation can be converted, but here is the case cannot be converted
Because of the earning.
because of the.
You fund
No,
supply,
because of the earning, because of our High Court judgment, my lord, 2006 to GLP. Even the last week, I given, submitted 3 judgment also on Justice Shimon Sham. That is something different, because there is a Orient Nations company filed the appeal challenging this 166, 163 is not maintainable, because it's more than 40,000 per annum. উপরের page তে আছে mortgage.
Okay, I'll go through these judgments.
So.
You have mentioned the
Lordship
paragraph
has not
number.
decided that part, that is, that Lekundas also. I already submitted, I have submitted 3 cases, my lord. One is my lord, Rita Devi's, and one is, my lord, Rita Devi's is the case of 163A. Because same case, facts and circumstances is the same case, you know, my case and Rita Devi's case.
And Purnima Singha.
And my lord, I'm giving that first judgment, dismissal judgment, there's a quoted 3 judgment. I also giving the copies of the judgment. I'm giving my lord 7 judgment for decision. Oh, I try to give the one, my lord, written argument because due to my paucity of time, I could not prepare today, sir. Just what it says, but maintainability like this.
You may do so.
Can do so, lordship is fixed on 8th of January. I'll submit on 5th of January for judgment.
Okay, on 5th you submit.
Yes, my written argument,
Yes,
along with this judgment.
okay. Yes, Mr. Talukdar.
My lord, in this case, with my,
You also submit your written gist
yes, I submit.
instead of, because I have heard you also.
I
Part
submit.
heard, my lord.
I'll keep it on part heard on 8th of January. Heard Mr. R.C. Paul, learned counsel for the appellant. Also heard Mr. I.A. Talukdar, learned counsel for respondent number 1. Learned counsel for both the sides are requested to submit written gist of their respective argument on the next date fixed. Let this matter be listed on 8th of January.
Submit.
My lord, if 8 is, it will be difficult because I'll be out of station.
You choose it.
11, after 11 it is.
After element, my lord, view.
Oh, no, okay, after 11 we'll fix it, no issue.
After 11, my lord.
19th or 20th,
20 January.
Yes, 20 January.
much of.
List this matter on 20 January as part heard matter.
My lord, written argument on before which date should be submitted?
Before, on 20 January you submit.
Yes.
No, you submit on to 20 January.
Otherwise it will be clash. Oblige.
This matter will be taken up after vacation, Lordship. I could not take instruction alone at all.
Oh, there was some query.
Yes, Lordship, that is why.
Let her take instruction. The issue was, what
Yes.
was the issue?
50 good shades.
Oh, yes, yes.
Passed by the balancing of
Only
the.
lawyers is required, my lord.
This is important.
This case or not,
Let her take instruction.
vacation.
Heard Mr. D. Rathi, learned counsel for the petitioner. Also heard Mr. R. Devi, learned central government counsel appearing for respondent, who seeks some more time for answering to the query posed by this court by order dated 11/12/2025. The prayer is allowed. Let this matter be listed when
After vacation, Lordship.
8th of January.
My lord, if it can be fixed first week of January, because I have a little urgency. in
First week means
The second week of January, my lord.
8th is in the second week,
Second.
January,
week.
ma'am.
Yes,
February. 8th of January,
January, yes, it is second week of.
8th of January.
First.
What the court will take up the matter at the second of the day. It may require some time.
Are you ready or not?
I have
You-
also, my lord,
Material of all records are not available. Even then, my lord, I prepared. But there are some documents which require to be considered by the court. Because, my lord, there are 3 different suits. They raised a question, my lord, so far the second suit is concerned. They raised a question that in view of the earlier suit, second suit is barred by res judicata. Therefore, my lord, if second suit is barred by res judicata, the decision given in the second suit cannot be a valid decision. Therefore, subsequent suit, third suit is barred by res judicata. Then that was the purpose finding by both the courts below without taking into consideration that second suit is barred by res judicata. My lord, so far as that part is concerned, my lord, I need some document because they have annexed 2 judgment. My lord, second suit, decree and judgment. But so far as the first suit is concerned, they did not produce any records. And plaints are also not available, written statements are also not available. And it is very unfortunate, my lord, senior advocate, my lord, Kina? B. Kolita sir, my lord, he expired and thereafter brief was misplaced. And later on, my lord, we
Yes,
are
Mr. Dhar.
hardly in a position, my lord, to prepare the case.
This
All
case,
documents
my
are
lord,
not available.
can be decided on the basis of the judgment passed by the learned trial court Munshi number 2 Karimganj, your lord. And so far as the lower, my lord, judgment passed by the learned appellate court below, my lord, it is not at all a judgment. My lord, so far as the provisions of order 41, rule 33 is concerned, your lordship. So, my lord, we are here concerned with the judgment passed by the learned Munshi trial court, your lordship. Now, what the learned Munshi said, your lordship, that, my lord, the present, my lord, appellant or the plaintiff Pramod Chandra Nath, and so also, my lord, the second, my lord, plaintiff, my lord, they were the parties. But if your lordship, my lord, compare page 74, plaint filed in the suit, and my lord, my lord, judgment and degree passed in my lord earlier suit 149 of 2067, then your lordship will find, my lord, the present plaintiffs were not the parties in the earlier suit. That is one aspect of the matter, your lordship. Now, findings of the courts below, my lord, so far as the trial court is concerned, they are stating, my lord, that the, my lord, matters in the earlier suit and the present suit, my lord, are the same. And that's why it is barred by the res judicata. And primarily on the ground of res judicata, my lord, the suit filed by the present appellant plaintiff was dismissed, your lordship.
But,
Now, my lord,
but to decide that question at the second appellate stage, we will have to go into the question of facts.
in summary, I know that it may not be possible to disclose the case today, but that is the summary, your lordship. They say that the present suit is barred by res judicata. And what is res judicata? Res judicata, my lord, as per the learned my lord, trial court, that the matters are the same. My submission would be, my lord, not the matters. It must be the issues, your lordship. What is the issues? Firstly, issues must be the same, and then parties are same. Now, in this case, neither the parties are same, and my lord, for that thing, I will have to go your story. Lord.
How much time will you take?
Everything is there, my lord, page 74 and
It is absolutely not
60,
correct, my lord.
87. These are the, my lord,
No, no.
74 is the plain file in this.
How
suit.
much time will you take?
Lord, I will take at least, my lord, half an hour, at least half an hour.
We don't have half an hour today.
So that's why, my lord, my
it is
submission
also
would
not,
be
my
if
lord.
my learned, my lord, I am coming, I will have to come back again.
Yes,
My lord,
yes.
I have thought.
Choose a date.
So let it be, my lord, any day after 16th of March as a fixed item, your lord.
Any date after 16th of March.
If my learned friend agrees, on
Yes, I
that
have no
sake, my
objection.
lord, he will not be allowed, this is for the last chance, my lord. And he
Yes,
may
yes,
not
I
be
am.
allowed to say all this. my
No,
lord.
no,
I am
next
not
time,
ready
next
and
day, I can assure you, lordship, my lord, I am not going to
This
take
is
any.
your submission all too much.
And the facts he has narrated, my lord,
Any
is
day, my lord,
absolutely not
I will
correct.
be coming on 16th of March and I will be there, my lord, up to 31st of March. Any hearing day, this matter will be
17th.
hard and disposed of, your lord.
19th March.
All false statements
And my lord, that's why, my lord, the court had to grant twice on the case records, your lordship. Once the court has formulated, my lord, Honorable Mr. Justice Monsam, my lord, he, my lord, said that whether the suit is brought by res judicata, it is to be seen, my lord, that is on, my lord.
Heard.
And my lord, the first order, and then, my lord, when the records came, now there is another order, your lordship will pass, fine, my lord. order
Additional
that,
issue is there.
Passed by.
Yeah.
That the defendant, in order to prove their case, my lord, they exhibited all, my lord, certified
Photocopies.
certified copies. And that is the judge, my
We have
lord,
checked
order
that, my lord.
passed by Honorable Mr. Justice Lord D. Borua, Devashish Borua. Two
Any
orders are there.
additional question of law
Le-
has been formulated.
They took
Okay.
this ground, they,
Okay,
my lord,
okay,
in
we'll go,
as a ground.
we'll consider everything.
Questions are formulated.
We'll consider everything on.
First,
I have
my
gone
lord,
through, I have gone through. Two
first, my lord,
questions
whether
as well
the
as the
learned
additional
court will
question.
Conclude the true purported intents of section 11 of the.
I have gone through those questions.
But by ignoring the fact the subject matter of both suits were, my lord, that is one aspect, then, my lord, came another order, your lord.
I have gone through.
My lord,
Heard
and then
Mr.
the
N.
court
Hur,
said,
learned counsel for the
yes,
appellant.
justified upon relying of exhibit.
Also heard Mr.
Mere photocopy.
A.K. Purkasta, learned counsel for the respondent.
Additional substantial question.
Stop. Mr. Purkasta, learned counsel for the respondents has prayed for an adjournment on the ground that
Because paucity of time, court may not be in a position today.
prayed for an adjournment. Stop. Otherwise also, due to paucity of time, it may not be possible to complete the hearing of this regular second appeal today. Hence, this has to be adjourned for the day. Mr. N. Dhar, learned counsel for the appellant, submits that he is presently stationed at Delhi and will be coming back in the month of March and
I may be available,
requests
16th of March,
that the
available, man.
that the case may be fixed in the second half in the month of March itself, to which Mr. Purkasta raises no objection.
Getting tickets
Stop.
and all that.
Considering the submissions made by learned counsel for the parties, as well as considering the fact of paucity of time, this matter is adjourned today. Let this matter be listed as a fixed item for hearing on 19th of March, 2025. 19 March.
And in addition to my oral argument, I just
My lord,
submitted written argument.
only my prayer is that on that date, my lord, 19th of March, we may not seek any.
My lord, that's why, my lord, I requested your lordship to drop that. My lord.
Your lordship will see how many times.
Next
they
day
have
he will
not
come, the
agreement.
Mr. Professor took time.
It's the last chance, my lord. that-
On that day, what will happen, we have to wait.
He will repeat the argument. He will
Let
say.
us wait for
It's
that
a fixed item.
fixed item.
Public.
Man, I will submit a written argument for the convenience of the.
Yes, it would be convenient.
By the time to go.
My lord, let him, so I may not, my lord, because I have already filed 2 affidavits, your lordship. I have filed 2 affidavits and it is not required for me, my lord, to file. a
Mr.
written
Dhar will not
My lord,
allow Mr. Hazarika to take place.
obliged, your lordship.
Lordship, my senior is, she's not well. She has to leave for today. So Lordship may pass any date after vacation, except for 7th January.
Heard Mr. P. Hazarika, learned counsel for the appellant. Also heard Miss D. Hazarika, learned counsel for respondent number,
My lord, the insurance company.
respondent / insurance company. who prays for an adjournment on the ground that conducting counsel for the respondent is not well. Considering the ground stated by the learned counsel for the respondent, the prayer is allowed. Let this matter be listed. When?
The hearing date, the first week, my lord, it is a appeal of 2018, my lord, by the claimant. They have not received any amount.
February.
On 6th, my lord.
Sixth of
My lord, January.
January, we have very less days and already we have posted
Well,
cases.
Take your hearing date. Sixth February. Oh, no, I beg you.
6th February is okay.
6th.
5th of February. Let this matter be listed on 5th of February.
Okay.
As fixed item.